Weekly list, item number 1.
One lordship, my learned senior is on his way to this court. Lordship, I pray for one Passover, my lords.
They have not filed the IMI.
I
Filed a bail
I-
application again by in 2023.
is pending.
2523. That has not been solved.
Why two interim applications have been filed for bail?
My lords, the earlier was on the ground of interim bail, my lords. On the ground that the father of the appellant was
That is 1533 of
2019,
2019.
my lords.
So that you do not want to press.
No, my lords.
That already some orders have been passed, man. It was 19, madam.
It was heard, my lords, by a coordinate bench, and thereafter,
No, it has not been disposed of because it has
Yeah.
come.
my lords, it is in the noting, but it has not been disposed of. At present, I would praise that
1533 of 2019. Mr. Das, he is right that this IA has not yet been disposed of. This
Which one,
earlier
sir?
IA.
double
Right.
Ma'am.
So, Mr. Das, you are not pressing the earlier interim application.
I'm pressing, I'm not pressing.
Okay. IA number 1533 of 2019. This is an application for bail. Land Council for the petitioner, appellant doesn't want to press this interim application. Accordingly, IA is disposed of. Yes. This IA is for interim bail or
For regular bail, my lord. Your lordship would find there are altogether 5 accused persons before the trial court, my lords.
it was earlier rejected on merit?
Yes,
It
madam.
was rejected, but since long, my lord.
Since long means when?
It was
It is in 2014, madam. 17/4/2014.
Just a minute.
17/4, no, 17.
17/11
11.
Right. Okay. Now, since when you are in custody?
in the earliest occurrence had taken place, my lord. On 24/12/2007, and he has been languishing also soon after the alleged incident.
No, soon after mane kon?
So we see that is my
Final
lord.
form that you dekhile?
Yes, my lord. That is 25/12/2007, my lord, as per the charge sheet, my lord. He was arrested
25/12/2007.
my lord.
That means it is 16 years you were in.
Yes, my lord.
And what is the offense here?
Offense is, my lord, present petition was charged under section 302
Hmm.
and 304B, my lords.
Hmm.
And he has been acquitted from 304B and convicted under section 302, my lords. Read with 498 IPC, my lord. That is
You
the
killed your wife
is my wife, my lord.
or by pouring kerosene.
For pouring.
What are the materials?
What are the materials, my lord? I'm placing, my lord. One of the material on a trial court has given much emphasis to the dying declaration, my lord. Dying declaration recorded by the PW1, my lord, who is the executive magistrate, my lord. And
so what Mr. Das says, you have not solved a copy.
Just now they saw. So
No.
if my lord will take in hearing, because paper is ready, my lord.
Are you ready for hearing? We can take out today itself.
We have not yet received the paper. We have lots of answers.
No. Get the paper book is ready. 2010 appeal. What is there?
Yes, sir.
If you say that it's a good case, it can be.
Let the bail application be insisting for the bail applications.
No. Bail, it's a different. It's a temporary thing.
Yes, ma'am.
But if you are ready, paper book is prepared. Why are you not getting?
Yes, we can argue, ma'am.
We are placing the matter next week.
Yes, ma'am.
I'm asking the registry to supply you the paper book.
Yes, ma'am.
Mr. Das, we can take up next Monday itself.
Madam.
So, click on to the IN number 2523 of 2023. This is an application for bail. During course of this hearing of the bail application, Mr. Devasnan Das, Land Council, appearing for the appellant, submitted that since the paper book is ready, he may be served with copy of the same so that we'll get ready to argue the matter next week.
Monday, my lord.
Mr. Arupanand Das, an additional government advocate, submits that he has received the copy of the
My lord,
paper.
paper.
In view of the submission made by the learned counsel for the respective parties, put up this matter on 5th February 2024 for hearing. Let the registry supply the copy, a paper book to the learned counsel for the appellant. By tomorrow, Korduchi, tongue day the way, the copy. All right.
Item 2.
Sir, I filed IA for conversion of case WPCRL to CRLMP.
To be converted to CRLMP.
CRLMP.
Yes,
Yes.
Mr.
My lord.
IA number 1 of 2024. This is an application for conversion of the WPCRL to CRLMP. Mr. Mr. Sachidananda Mahapatra, learned counsel appearing through Vichitananda Mahapatra, learned counsel appearing through virtual High Court, Kurdad, Bhubaneswar. Learned counsel for the state has no objection to such prayer.
Let them serve a copy also. They have not served the copy.
On formal.
Conversion ପରେ ଗୋଟେ copy ତ
All right.
conversion WPCR ଟା ଦେଇନାହାନ୍ତି ତ conversion ହେଲା ପରେ ସେଟା ପୁଣି ଆମକୁ ରହିବ।
I'll say that. The accordingly, the land council for the state has no objection to such prayer. Accordingly, IA is allowed, and the WPCRL be re-registered as CRLMP and be placed before the assigned bench. Let a copy of the CRLMP be supplied to the land and council for the state. So we allowed your prayer. Please serve a copy of the application on the state council. Okay,
Yes, sir.
is to come before the assigned bench.
Yes, sir.
CRLMP, I think it is for assignment of the single bench.
Yes.
Yes.
Item 3.
3 wrongly it has come because it has been posted to 26/2 February. It has
Oh, भूल लिखा है 26 January. Okay. All right. The Learned Council for the state submitted that the case was adjourned to 26th February 2024. We commencing from 26th February 2024 as per order dated 16/1/2024. But inadvertently, since in the order number 10 dated 16/1/2024, the date has been mentioned to be 26th January 2024. It has come for admission and the matter may be taken off in the week commencing from 26th February 2024. The Land Council for the petitioner has no objection. Let this matter be listed in the week commencing from 26th February 2024. Yes.
So meanwhile, my lord, what is anticipated bail application have been rejected, my lord.
You get the Land Council for the appellant file some documents which are taken on record. Okay.
Item 4.
In this case also, my lord, it has been fixed to 26th February.
अरे किए गुड़ा लिखो जी के हाँ Mr. Raut हाँ 26 February 26 January लिख दो सेम ऑर्डर कर दूँ
Item 5.
इधर ऐसे जो किसी दही ना दिखा ले डॉक्यूमेंट किसी दो देने पर Yes.
Here, my lord, the state sentence review board has rejected the prayer of the present petitioner only on the ground, your lordship, page 26, only one ground, that due to young age, he has not lost his potential for committing further crime. This is the only ground.
Just a minute. You are challenging the rejection order
Order
passed by the State Sentence Review Board.
under
Okay,
Annexure 5.
Annexure 5. In rejecting your prayer for premature release. Or what is the ground taken?
Ground, your lordship may go through the page 26. Kindly.
26.
26 last.
Last.
Serial number 63.
63.
Madam.
Gradually, so. Discharge fully due to young age, he has not lost his potential for committing further crimes.
Right.
Okay.
So, my lord, my respectful submission is that
Okay, first tell us that what is the conviction and what is the sentence imposed? What is the trial court judgment?
trial court
And the appeal has been adjudicated finally by this court.
appeal has been dismissed.
What is your date chart?
Date chart, my lord, I have filed. Second page, your lord.
6/8/2002. You are in. And you are convicted the petition under what offense?
302, my lord.
Only
302, 307, 25, 27 Arms Act.
judgment copy ଅଛି trial court ର appellate court ର
My lord,
appellate court କଣ କଲେ?
appellate court dismissed करते.
କାଇଁ ଲେଖି ନାହାନ୍ତି?
Yes, I have
ଡେଟ୍ ଚାର୍ଟ ରେ ଲେଖି ନାହାନ୍ତି? କିଏ ଲେଖିବ? appellate court पूरा confirm କଲେ ନା କୌଣସି sentence conviction କୁ set aside କରି କଣ ରଖିଲେ କେମିତି ଜାଣିବେ?
My lord, entire things I have mentioned in the paragraph wise, your lordship.
Why are you not mentioning in the date chart?
Date chart.
When you are preparing a date chart, you are supposed to mention so that it would be. Then what is the purpose of filing this date chart?
Then,
if you keep everything.
If your lordship want to, then I will file it tomorrow.
Yes.
Date chart along with the judgment of the Lord.
Right, that should be filed.
Yes, ma'am. Entire things I have
Then he
mentioned.
preferred SLP. SLP was
SLP dismissed. Paragraph 4,
Keep
5.
that date and don't leave it out, because once we write a detailed order, we have to mention everything in that. Okay.
Tomorrow I will file.
No, we are giving one more day time. We are keeping it.
Then
we are taking up this matter on Wednesday from this weekly list.
Yes, ma'am.
Okay.
Yes, ma'am.
That copy you serve on the London State Council. Okay.
Tomorrow I will serve it and file it.
So, Mr. Das, just this man is in custody for more than 21 years.
In fact, my lord,
if his date chart mentioned
19 years.
ସେ କହୁଛି 6/8/2002 petitioner was taken into custody. Bail ରେ କିଛି ଲେଖି ନାହାନ୍ତି? bail ରେ ଯାଇଥିଲେ କି?
page 20, my lord, 40.
bail ରେ ଥିଲେ?
Yes, ma'am. Bail ରେ
ମୁସ୍କିଲ କଥା.
No, my lord. I am on bail. No, at no point of time I haven't released. But interim parallel have released.
ଯଦି ଅଛି ସେଗୁଡା ସବୁ ଲେଖୁନାହାନ୍ତି କଣ?
My lord, custody certificate I have filed. Annex 2.
Please mention it in the date chart.
Yes.
Okay, don't leave anything.
I will submit, my lord, tomorrow entire date chart. Though I have.
Have you filed your counter affidavit?
They have
what ground you have taken?
We have only taken ground that, my lord, as per the guidelines, my lord. Can you turn to our counter, my lord, page, my lord, 11, my lord. The 5, my lord. 5A. Whether the convict has lost his potential for committing crime, considering his overall conduct in jail during the 14 years incarceration, my lord. On that ground, it has been rejected, my lord.
No. Last week also a matter was placed, and the law which has been laid down by the Honorable Supreme Court is that what was the guideline which
At the
was
time of the-
prevailing at the time of conviction.
My lord.
So that is to be taken into
Yes, my
account.
lord.
This guideline is of the year 2022.
22, my lord. Also,
he
at the
was
time of
found
conviction,
guilty
Yes.
in which year?
2000
That the date chart indicate
conviction, my lord.
2012, my lord.
2012.
12.
So have
2002.
you found out that decision?
My lord.
That there is a decision of the Honorable Supreme Court that the guideline which was prevailing at the time of conviction is to be taken into account, not that in subsequently.
Yes, yes.
And if the subsequent one is more, that means beneficial to the accused, that can also be taken into account. So whichever is beneficial to the accused, that is to be taken into account. So time to time, I think 4 guidelines they have formulated so far as this remission is concerned. So we are concerned with that what was prevailing on 21/3/2012 when you were found guilty. That also you examine.
Yes, ma'am.
Suppose in that guideline there is no such thing about the potential to commit the crime, young age, etc. Then that cannot be a ground to reject your application for premature release. Okay.
Exactly, ma'am.
So get ready. We'll take up this
Yes.
matter day after tomorrow.
Tomorrow, ma'am.
Okay.
Ma'am.
All right.
Give a detailed date chart.
Date chart along with the
judgment
Judgment.
passed by the trial court and
Right.
confirming order of this court in the appeal.
public
It will be list called from this weekly list.
weekly list, my lord. Day after tomorrow.
Yes.
Public.
31, 20. Yes. Huh? Oh, no. Oh, that will be.
Item 6.
Let's see, as per let's see direction, I have filed the affidavit by the petitioner. First copy दे दी थी, second copy दे न थी.
Mr. Das, the status report which you submitted on the last date, 16/1/24, of the investigating officer, that indicated that the
Girl
rescued minor girl was handed over to the parents on 8/1/2024.
Mother.
And since that day, she had been staying with her parents.
Mother.
The Learning Council
made
disputed
an allegation, my lord. Accordingly, I have filed an affidavit also, my lord.
Yes.
My lord also wanted the 161 and 164 statement.
No, that has come, but
My lord.
what affidavit you have filed?
I have filed it on that day, my lord.
Hmm.
Kindly come to the para, my lord.
Hand over a copy to the
Already comes.
out a copy. Yes, what you have mentioned?
My lord. Page 3, my lord.
Hmm.
First in, my lord, it is second para, my lord. It is further submitted that on 6/1/2024, the 162 statement recorded could not be recorded by the SDGM Banki due to the late hour. The IO requested the petitioner to take his daughter with him and to produce her on 8/1/2024 before the land SDGM Banki for recording her statement under section 161 CRPC matter. But the petitioner denied to take her daughter, for which the child was kept in the child care unit, my lord, on 6th, my lord. Then, my lord, 8/1, he was produced before the land SDGM Banki, and her 161 statement was recorded. And it is humbly submitted that after recording the 162 statement, the IO issued notice and informed the parents to take their daughter with them. But the parents refused to take, and also the parents refused to take the notice and said that they will never accept their daughter, and further submitted that they will take their daughter only from the Honorable High Court. Since the petitioner refused to take notice and denied to take her daughter, the cousin brother of the petitioner, namely Sarveswar Parida, who had accompanied with the petitioner, after discussion with the petitioner, IO, and also with the victim, assured the IO that he is taking the victim with him to the house of the parents and he will convince their parents. Accordingly, the victim was allowed to go with the Sarveswar Parida along with her parents on 8/1/2024. Accordingly, as per the instruction of the IO, so and so, I submitted the report dated 13/1/2024. Copy of the that, my lord, given undertaken by the Sarveswar Parida is annexed, my lord, as D/2. Then, my lord, on that day, on 16/1, when I informed the IOC regarding the, then he immediately contacted the IO and also to the Sarveswar, and they produced the victim, and the victim now in the, my lord, the child care, my lord, unit, Lokanai Club, my lord.
It's come to the status report which you have
My
submitted.
lord. And we have never handed over the, their allegation that we handed over it to the accused, my lord.
No, we first you saw that how it is contradictory.
My lord, my lord.
We are placing reliance on the last line,
My lord.
last sentence.
Yes, sir. I will
13/1. 8 adhyay. The rescued minor girl Lakshmi Priya Parida was handed over to her parents on 8/1/2024, and since that date she has been staying with her parents happily. So this is the status report.
The 13/1,
dated 13/1/2024, right? Now what you have stated, in your paragraph 6, again you read. On 8/1/2024, the victim was produced, recorded. It is humbly submitted that after recording of 164 CRPC statement, the IO issued the notice and informed the parents to take their daughter with them, but the parents refused to take, and also the parents refused to take the notice and said that they will never accept their daughter, and further submitted that they will take their daughter only from the High Court. Since the petitioner refused to take notice and denied to take the daughter, the cousin brother of the petitioner, namely Sarveswar Parida, who had accompanied the petitioner after discussion with the petitioner, the IO and also the victim assured the IO that he is taking the victim with him to the house of the parents and he will convince their parents. And accordingly, the victim was allowed to go to Sarbeswar Parida along with her parents on 8/1/2024. Accordingly, the instruction of the IO, Swantrai submitted the report. So this is completely contrary
My lord,
to what you have stated in this one. So, okay.
my lord,
Not only that, the SDGM Banki has submitted the report
my lord,
wherein it is mentioned
my lord.
that it is important to mention that on 8/1/24,
My lord.
Sri Karma Lakra SI of Banki Police Station has prayed to this court to record the statement of the victim Lakshmi Priya Parida, aged about so and so under section 164 CRPC, and as per the prayer of the IO, the statement of the victim was recorded under section 164 CRPC. Further, it is pertinent to mention that IO has not made any specific prayer to hand over the victim to her parents. So no order was passed by this court to hand over the victim to her parents. On 22/1/2024, an intimation is received from the IO of the above case in which he mentioned that as the parents denied to take the minor victim girl Lakshmi Priya Parida, gave requisition to the coordinator Open Shelter Basundhara Swanso for giving shelter to the minor victim girl, and she was left on 18/1/2024 at Basundhara Bidanasi Katak along with other facts. So that means the whatever what you have mentioned, on the earlier status report, that is completely contrary to this present affidavit, which has been filed by the IAS. You have not mentioned that the parents refuse to accept their daughter, and that is why how the one Sarbeswar Parida, who is to be the cousin, he said that I will convince, and it was left in his company. All these things are subsequent story which is not there in the.
Have you received the affidavits filed by the petitioners, also his wife? There they have clearly stated on oath that after their daughter was rescued, she has been handed over to the parents of the accused Ranjan.
There is no accused.
And they are and now she is staying with them.
That no accuser, because it was not rescued from the accused, my lord. It was the victim was rescued from his aunt house. And my lord, kindly go to the 164 statement. That is also false. They have stated that is also false, my lord, because there is no accused. No accused has been arrested. No accused. He has not been rescued from the accused, my lord. The question of handing over the accused is not correct, my lord.
No, at present, as per the report of the SDGM Banki,
My lord.
the girl is staying with in Basundhara Bidanasi Katak.
Sir.
Sir, who are you?
IAS Banki.
How did you submit a false report? Why you will not be proceeded for contempt of court? ଆପଣ 8 ତାରିଖ ଦିନ ଯୋଉ ଷ୍ଟାଟସ ରିପୋର୍ଟ ଦେଇଥିଲେ 13 ତାରିଖ ଦିନ ସେ ଦେଖିଲେ ତାଙ୍କ ରିପୋର୍ଟଟା ଦେଖିଲେ ପଢନ୍ତୁ କଣ ଲେଖିଛନ୍ତି ଲାଷ୍ଟ ଲାଇନରେ ଲାଷ୍ଟ ସେଣ୍ଟେନ୍ସ କଣ ଲେଖିଛନ୍ତି?
SQ. So the rescued minor girl Lakshmipriya Parida was handed over to her parents on 8/24, sir.
पढ़ंतु कंप्लीट करंतु सेंटेंस
And since that she has been staying with her parents happily, sir.
ओडिया रे बुझांतु कोन ता माने
तो से लक्ष्मीप्रिया परिडा उद्धार ही तार बाप माँ को दिया है 8/24 रे एवं सेबेठारु से तार पेरेंट बापा माँ को सहित रहउछि
केमती रहउछि खुशी रे रहउछि वर्तमान आपनकर येटा पढ़ंतु जो एफिडेविट आज देइछन 8 तारिख रे कोन हला come to page 3 of your affidavit paragraph 6
sir on 8/24 sir the victim was produced before the Laurent SDJ Banki sir and her 164 CRP statement was recorded. Copy of the 164 CRP statement is annexed here with you, sir. It is humbly submitted that after recording of 164 CRP statement, the IO issued notice and informed the parents to take their daughter with them, but the parents refused to take, and also the parents refused to take the notice and said that they will never accept their daughter, and further submitted that they will take their daughter only from the Honorable High Court. Since the petitioner refused to take notice and denied to take her daughter, the cousin brother of the petitioner, namely Sarveshwar Parida, who had accompanied with the petitioner, after discussion with the petitioner IO and also with the victim, assured the IO that he is taking the victim with him and to the house of the parents and he will convince their parents. Accordingly, the victim was allowed to go with Sarveshwar Parida along with her parents on 8/24. Accordingly, as per the instruction.
এই जो जिनसटी वर्तमान लिखिले এইটা ଆଉ ଆପଣଙ୍କର ଯୋଉ ଷ୍ଟାଟସ ରିପୋର୍ଟ ରେ ଯାହା ଲେଖିଛନ୍ତି ଏଟା ଏଟା ସମାନ ଜିନିଷ ନା ଟୋଟାଲି ଅଲଗା ଜିନିଷ ସେଠି ଲେଖିଲେ ଯେ 8 ତାରିଖ ଦିନ ଭିକ୍ଟିମ ରେସ୍କ୍ୟୁ ହେଲା ପରେ ତା ପ୍ୟାରେଣ୍ଟସ୍ କୁ ହ୍ୟାଣ୍ଡ ଓଭର କରି ଦିଆଗଲା ଏବଂ ପ୍ୟାରେଣ୍ଟସ୍ ଙ୍କ ସହିତ ସେ ଖୁସିରେ ରହୁଛି ବର୍ତ୍ତମାନ ଲେଖୁଛନ୍ତି ନାଇଁ 8 ତାରିଖ ଦିନ ତାର ବାପା ମା ମାନେ ରାଜି ହେଲେନି ତାକୁ ନବା ପାଇଁ से विक्टिम रो गोटे कजिन किए सी कहला मते मो पाखरे से विक्टिम को दियो मु ता बापा माँ को कन्विन्स करेबी एवं सेही पई सर्वेश्वर परिडा सहित विक्टिम को छड़ा हला 8 तारिख दिन
से जो से विक्टिम को जो नंबा को देले से सर्वेश्वर परिडा ताको नै की गला
सर से तार सारे आयो सारे ताको प्रोड्यूस कला
सर्वेश्वर परिडा संगे रे से गला
आगे सर
से तोळ आउ केई नथिले
नै सर ता बाप मा थिले सर
बापा मा सर्वेश्वर परिडा सब मिसिक ताको नेले
समस्त थिले सर समस्त नेले सर
आ एमतिया केमति रिपोर्ट दे देले स्टेटस रिपोर्ट रे ता बापा माँ को सहित सर्वेश्वर परिडा कथा टोटल नाही आपनकर जो स्टेटस रिपोर्ट देइथिले 13 तारिख दिन से विषय रे ए सब कथा उल्लेख अछि की
नाइ सर सेटा नाही सर आयो मते सर से मते कहि देला जतले सर मते पचारले जे
आउ एसडीजीएम जो रिपोर्ट टी देइछंदी जोटा आज आसी पहुंची छी सेटा सेटार किछि लेखा हिनी आपनकर जदी विक्टिम गर्ल कर स्टेटमेंट रेकॉर्ड हला 8/1/2024
सर
से स्टेटमेंट पड़ा हला
मतलब पेज 9 में 3/2
you are not the IO
नाइ सर
ना इज द आईएस you see that statement
sir
जियो कौन कहला लास्ट दी लाइन
सर से मु मो निज इच्छा रे चल जाइथिली वर्तमान मु मो बाप मां को
वर्तमान मु मो बापा मां को पाखरे रहिबा को चाहूची
सर
एई जो दिन रेकॉर्डिंग हला 8/1/2024 दिन तार बापा मां आस्तिले कोर्ट को
आस्तिले सर
हां
आस्तिले सर
कोन हला बापा मां कोन कहले
सर बाप मां तार पूरा डिनाय कले सर जतले ऑनरेबल एसडीएम कोर्ट रे तले रेकॉर्डिंग पई से जतले जियो को निया गला सर से समय जो आयु को पचाले तार बाप मां से जतले जाई बसिला से तार मां जाई बसिले से झियो जाई की कहला जे मो मां बसिले
मु एते कथा जानिनी 8 तारिख दिन झियो विक्टिम स्टेटमेंट दउची मजिस्ट्रेट को पाखरे मु मो बापा मां को पाखरे रहिबा को चाहूची
सर
बापा माँ कोर्ट रे उपस्थित थिले ताले बापा माँ को पाखुकु छड़ा बापा माँ को हिफाजत रे झियो को कौन पाई न दिया गला
सर से मना कले सारे नेबेनी बोली सारे कहिकरी पूरा
किए कहले
सर बाप माँ उभय थिले सर सेठी सर
कौन पाई लिखिले स्टेटस रिपोर्ट रे बापा माँ को दिया गला बोली बापा माँ पाखरे से खुशी रे अछि बोली 8 तारिख दिन
सर आईओ सर मु पचारली सर सार मते कहले जे से
आपण भी जिबे चौद्वार जेल आपण को आईओ भी जीवो we are not satisfied with this affidavit you are telling falsehood call that IO tomorrow what is your name
सर शिव चरण बेहरा
Mr. Sibocharan Behra the inspector in charge of Vanki police station is present. He has filed an affidavit. After going through the 164 CRPC statement of the victim, which is annexed to the affidavit as annexure C by 2, and looking at the averments taken in paragraph 6 of the said affidavit, vis-a-vis the status report submitted by the IIC Banki police station on 13/1/2024 and the report furnished by the learned SDGM Banki, we find that it is completely contrary to contradictory. In order to ascertain the correct state of affairs, we also peruse the affidavits filed by the parents of the minor victim. Put up this matter tomorrow. The IIC Banki police station, so also the investigating officer of Banki PS case number 325 dated 15/9/2023, namely Kondana
सर कर्मा लाक्रा सर
Karma Lakra shall appear tomorrow in person before this court at 10:30 a.m. Free copy of the order be handed over to the Learned Council.
Can I receive a copy of the learned JMFC, my lord?
A copy of the report submitted by the Learned SDGM be supplied to the Learned Council for this state. Yes. Affidavit filed by the this affidavit filed by this one taken on record. It again the affidavit asila record scanning agent. Oh, second copy but the affidavit is on record. It was second copy 2016 one. Scanning. Yes. ये करे दी सानुभव पटेल कोट करो सारा सिस्टम पूरा कोट कर दो yes the given portion of which is quoted below
Item 7.
As per my lord direction and lordship on 28/11/2023, we have produced the victim before the JMFC hearing on 22/1/24, you know.
So the order which we passed on 16/1/2024,
My lord. We have produced the girl, victim girl before the JMC nearly, my lord.
केवे produce कले?
By secret, I have given the
कहीं?
I
ऐसा दोनों? Then what happened on that day?
statement recorded probably.
No, no. By जो 22/1/2024 रे
Hey,
तू जेएमएफ सिंह नियालिंग पाखरे प्रोड्यूस कले
hey.
कौन ऑर्डर हैला कौन हैला?
Your lordship was directed to submit a report by the JMFC nearly, my lord.
Directed to submit a report in that respect so on so. No, that order was passed on 16/1. What complaint? Okay. Report किसी ऐसी में देता हूँ कोई हाँ? कौन हैला से दिनों?
The learned JMFC asked regarding the how she is living with the parents. She said also that she is living happily and with the parents and prosecuting the study.
तापर कौन हैला? आपनों को हेफाजत रे छाड़ी ले? So the victim now is staying in your company. All right, sir. मैं पाके रोज dispose of लेखों. The Learned Council for the state has produced the written instruction received from Chairperson Child Welfare Committee, Cuttack District, Odisha, regarding production of the victim girl before the Learned JMFC Niali on 22/1/2024. Along with the undertaking given by the petitioner to take care of her minor daughter properly and to keep in contact with CWC authorities. The written report along with the undertaking taken on record. The Learned Council for the petitioner submitted that on 22/1/2024, the Learned JMFC Niali ascertained the well-being of the victim girl from her, and when she told that she has no difficulty, she is facing no difficulty in staying in the company of her mother bracketed petitioner, she was allowed to stay in the company of the petitioner. In view of the submission made by the Learned Council for the petitioner and the report furnished by the Learned Council for the state, and since the order dated 16/1/2024 regarding production of the victim girl before the court has been complied with, no further order, and the victim girl is now staying in the company of her mother bracketed petitioner. No further order is required to be passed in this WPCRL, which is accordingly disposed of.
So much obliged.
Item 8.
BBC, may I plead your lordship? From Puri BC, may I plead your lordship?
My lord, in this case, we have not received copy.
Thrice I have sought copy by thrice after on the day of filing and after my lord's direction on dated my lord's direction on dated 10 1 2023 my lord. Thrice I have sought copy.
There was a learning council, there was a direction on 16/1/2024.
Yes.
When the learning council for the state made a submission that the copy of the WPCRL has not been served on him, we asked you to serve a copy on the London State Council so that he will obtain instruction. So you are supposed to serve a copy after 16/1/2024.
Immediately on the date 16/1, immediately after my lord's direction, I served copy. But their submission of receipt is somehow different than our High Court, my lord. I engaged in my work. I could not collect the receipt, my lord. But I saw they have received the copy, my lord.
What was the mode of serving the copy?
The collector from one staff from collectorate come and takes the copy, my lord, online, my lord.
Copy केमती सर्व कले?
One staff from district magistrate's office comes to the BC and takes the copy online.
Is it so?
District magistrate office copy तो नहीं.
ଏତେ କୋଉଦିନ କପି ଆସିକିରି ସେ ଯୋଉ ଇସ୍ୟୁ ହଲ୍ ସେଠି ଯାଇକିରି କଲେକ୍ଟ କରିକି ସେଠି ଦଉଛନ୍ତି ବୋଲି ସ୍କାନ୍ କରିକିରି ସେଠି ତ
I will ascertain, my lord. We have not received copy.
My lord, 2.5 years girl have been my lord.
No, that is unless we asked you just to serve a copy so that you will obtain instruction. So
I
many
have
things
some.
have passed, but the London Council for the State is making a complaint that he has not received the copy of the WPCRL. How will he obtain instruction?
Yes, my lord, I understand. I understand, my lord. But I have solved the copy. My wrong is only that I could not collect the receipt.
Sir, there is a mail ID of Learned Advocate General where you can serve copy, scanned copy through email. Why don't you do that?
Now I will send my lord. Now immediately I will send matter may come. Matter may come tomorrow, my lord.
And the virtual court where from you are appearing, there are competent staff who can assist you to do the needful.
Okay, we are just to do the needful during course of the day. All right.
Yes.
Tomorrow this matter will be called from the weekly list. All right.
Yes, my lord. Obliged, my lord.
Item 9.
Your Lordship, I'm appearing on behalf of Mr. Mishra. Sir, now he is present in other court, so
No,
please
sure.
adjourn the matter post lunch, sir.
The laborers are being rescued, man.
Rescued.
Yes.
No, just serve a copy, Mr. Mishra.
Is he not aware about the fact of rescuing the victim? Take instruction.
Migrant
Okay,
has
sir.
rescued so and so.
Okay,
Okay, we'll take up this matter tomorrow. He has handed over your copy. Please pass it on to the Mr. Mishra so that let him go through it and obtain instruction from the client, we can take up this matter tomorrow. Okay?
Mobilize
Zero.
process.
Item 17. Item 17.
17.
17.
Yes.
ಇದರ ಪಾಠ ಇಟ್ಲ ಅದ ಇಟ್ಲಾಗ ಡಿಸಿಷನ್ ಬಾಬೆ ವಾಕ್ಯ ಬಂಚಿ ಕೊಟ್ಟು ಪಾಸ್ವರ್ಡ್ ಇಟ್ಲಾಗ ಐಟಮ್ ವಾಂಟನೆ ಕೊಟ್ಟು ಇಟ್ಲಾಗ ಪಾಸ್ವರ್ಡ್
Aji.
ಐಟಮ್
ନାଇଁ 500 ଓଭର କିଛି ଅଛି କି 1 ରୁ 9 ଭିତରେ?
ନାଇଁ।
So please call item number 17.
Item 17.
May I please proceed?
Yes.
ଏଇଟା ଆପଣ କହିଥିଲେ କି ଡିସିସନ ଆଣିବା ପାଇଁ ଡିସିସନ ପାଇଁ କି କହିଥିଲେ?
No, just recapitulate
Yes, sir.
when this matter was last heard.
3-1.
Just recapitulate.
Reading FIR matter. ମୋର ନାମ
Please come to the FIR. Let us see.
FIR. ମୋର ନାମ କେଶବ
Can I have gone to the last order, my lord? 3/1/2024, my lord.
3-1.
My lord.
Yes. 3-1 over. P124 kind order standing in. Please place that FIR. Let us see that.
page 21 my lord.
Yes.
Yes. ମୋର ନାମ କେଶବ ସାହୁ, ପିତା ଜଗତ ସାହୁ, ଲେଟ୍ ଜଗତ ସାହୁ, ବୟସ 77 ବର୍ଷ, ଗୁଣ୍ଡୁପାଲି ଥାନା ପାଟନାଗଡ଼, ଜିଲ୍ଲା ବଲାଙ୍ଗୀର। ଆଜି 28/4/2001 ରାତ୍ରି 12:30 ସମୟରେ ଆପଣଙ୍କ ମାହାରପାଲି ଠାରେ ଏକ ଏହି ମୌଖିକ ରିପୋର୍ଟ ଦେଉଛି ଯେ ଆମ ଗାଁର ଘାସି ବଗର୍ତ୍ତୀଙ୍କ ଝିଅ ବେଲମତି 55 ବର୍ଷକୁ ଜଗଲପାଟ ଗ୍ରାମର ଦଳଜଞ୍ଜନ ବାଗକୁ ବାହା ଦେଇଥିଲୁ। ବେଲମତି ମୋର ମିତ୍ର ଝିଅ, ତେଣୁ ସେ ଅନୁସାରେ ତାଙ୍କ ଘର ସହ ମୋ ସମ୍ପର୍କ ଅଛି। ଆଜିକୁ ପ୍ରାୟ 4-5 ବର୍ଷ ତଳେ ବେଲମତିର ସ୍ୱାମୀ ମରିଯିବାରୁ ବେଲମତି ମାହାରପାଲିକୁ ପଳାଇ ଆସି ମାହାରପାଲିର ପବିତ୍ର ବାଗର ଗୋଟିଏ ଘରେ ତାର ମଝିଆ ଝିଅ ଉଦିଆ ସହିତ ରହି କାମ ଦାମ କରି ପେଟ ପୋଷୁଥିଲା। ଆଜକୁ 6 ମାସ ତଳେ ସେହି ମାହାରପାଲିର ପଞ୍ଚାନନ ଉଦୁର କରୁଣା ସହିତ ତାର ଝିଅ ଉଦିଆକୁ ବିବାହ କରାଇବା ପାଇଁ ପ୍ରସ୍ତାବ ପକେଇଥିଲେ। ସେହି ଦୃଷ୍ଟିରୁ ପଞ୍ଚାନନ ବେଲମତି ଘରକୁ ଯା ଆସ କରେ ଓ ତାଙ୍କର ହାନି ଲାଭ ବୁଝାବୁଝି କରେ। ପଞ୍ଚାନନ ଉଦିଆକୁ ବିବାହ କରିବାକୁ ଜିଦ୍ କରିବାରୁ ବେଲମତି କିଛି ଦିନ ପରେ ବିବାହ କରାଇବା ପାଇଁ କହିଲା, କିନ୍ତୁ ପଞ୍ଚାନନ ଶୀଘ୍ର ବିବାହ କରିବା ପାଇଁ ଜିଦ୍ କଲା। ତେଣୁ ଏହାର ସମାଧାନ ପାଇଁ ବେଲମତି ଆମ ଗାଁକୁ ଗଲା ଏବଂ ମୋର ଝିଅର ଅସ୍ପଷ୍ଟ ପଟାଇ ଦେବ ବୋଲି କହି ମତେ ଓ କୁବେର ବଗର୍ତ୍ତୀକୁ ମାହାରପାଲି ଆଣିଲା। ଆମେ 27/4/2001 2001 ଶୁକ୍ରବାର ଦିନ ମାହାରପାଲିକି ଆସିଲୁ। ସେଇଦିନ ମିଟିଂରେ କିଛି ମୀମାଂସା ହୋଇପାରିଲା ନାହିଁ। 28/4/2001 ଶନିବାର ଦିନ ଗୌନ୍ତିଆ ଘରେ ମିଟିଂ ହେଲା। ମିଟିଂରେ ମାହାରପାଲିର ଗୌନ୍ତିଆ ପବିତ୍ର ବାଗ ଓ ଅନ୍ୟମାନେ ଉପସ୍ଥିତ ଥିଲେ। ପଞ୍ଚାନନର ଭାଇମାନେ ନିରାକାର ଓ ଅନ୍ତର୍ଯାମୀ ମିଟିଂକୁ ଆସିଲେ। ପଞ୍ଚାର ମାଇଣ୍ଡ ଟେନସନ ଅଛି, ତାକୁ ମିଟିଂକୁ ନ ଡାକିବା ଭଲ ବୋଲି କହିଲେ। ମିଟିଂରେ ପଞ୍ଚାନର ଅନୁପସ୍ଥିତିରେ ସମାଧାନ ହୋଇ ନ ପାରିବାରୁ ମୁଁ ବେଲବତୀ ଓ କୁବେର ବଗର୍ତ୍ତୀ ବସରେ ଗୁଣଗୁଟପାଲି ଯିବା ପାଇଁ ମାହାରପାଲି ଛକକୁ ଯାଇଥିଲୁ। ମତେ ଝାଡ଼ା ମାରିବାରୁ ମୁଁ ଆଗ ପଳାଇ ଗଲି। ବେଲମତୀ ଓ ତାର ଭାଇ କୁବେର ପଛେ ପଛେ ଆସୁଥିଲେ। ମୁଁ ମାହାରପାଲି ଛକରେ ଥିଲି। ସେତେବେଳେ ଉପର ବେଳା 5ଟା ବାଜିଥିଲା। ଏହି ସମୟରେ ବେଲମତୀ ତାର ପେଟକୁ ହାତରେ ଚିପି ଧରି ମୋ ପାଖେ ଆସି ପହଞ୍ଚି କହିଲା ଯେ ତାର ପେଟକୁ ପଞ୍ଚାନନ ଭୁଷି ଦେଲା, ଯେ ରକ୍ତ ବାହାରୁଛି। କୁବେରକୁ ଛୁରୀରେ ଭୁଷି ଦେବାରୁ ସେ ମହାଜନପଡ଼ା ସ୍କୁଲ ସାମ୍ନାରେ ପଡ଼ିଯାଇଛି। ମୁଁ ପେଟରୁ ରକ୍ତ ବାହାରୁଥିବାର ଦେଖି ବୁଢ଼ୀକୁ ପାଖ ଡାକ୍ତରଖାନା ନେଲି। ବର୍ତ୍ତମାନ ତାର ଅବସ୍ଥା ସାଂଘାତିକ ଅଛି। ମରିବ କି ବଞ୍ଚିବ ଠିକ ନାହିଁ। ପଛେ ପଛେ ଆସି ଦେଖିଲି ଯେ ହରିଜନପଡ଼ା ସ୍କୁଲ ସାମ୍ନାକୁ ଆସି ଦେଖିଲି ଯେ ହରିଜନପଡ଼ା ସ୍କୁଲ ସାମ୍ନାରେ କୁବେର ବଗର୍ତ୍ତୀର ରକ୍ତ ଜୁଡୁବୁଡୁ ହୋଇ ମରିଯାଇଛି। ତାପରେ ଗାଁର ଗୌନ୍ତିଆକୁ ଉକ୍ତ ଘଟଣାମାନ କହି ତାର ପୁତୁରା ସହ ହସ୍ପିଟାଲକୁ ସାଇକେଲରେ ଯାଇ ବଲାଙ୍ଗୀର ସଦର ଥାନାକୁ ଫୋନ କଲୁ ଓ ଘଟଣା ବିଷୟରେ ଜଣାଇଲୁ। ଟେଲିଫୋନ ଖବର ପାଇ ଆପଣ ସଦର ଥାନା ବାବୁ ସଦଳ ବେଳେ ଘଟଣାସ୍ଥଳକୁ ଆସିବାରୁ ଆପଣଙ୍କୁ ଏହି ମୌଖିକ ରିପୋର୍ଟ କଲି ଯେ ମୋର ମୃତ ପୁଅ କୁବେର ବଗର୍ତ୍ତୀକୁ ପଞ୍ଚାନନ କରୁଆ ଛୁରୀରେ ଭୁଷି ମର୍ଡର କରିଦେଇଥିବାରୁ ମୋର ମୃତ ଝିଅ ବେଲମତୀକୁ ହାଫ ମର୍ଡର କରି ତାର ବିରୁଦ୍ଧରେ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ କରାଯାଉ। ପଢ଼ି ଶୁଣାଇ ଦେବାରେ ମୁଁ କହିବା ତାকে ଠିକ ଲିଖିଥିବାର ଜାଣି ମୋର ଦସ୍ତଖତ ଦେଲି।
You made a submission on the other day that there are two eyewitnesses to the occurrence. One is
one eyewitness ବେଲମତୀ,
but PW11 and PW12 ରେ କହିଥିଲେ ସେଦିନ। PW11 ତ ହଉଛି injured, right?
ଆଜ୍ଞା।
So who is PW12?
12 ହଉଛି ବେଲମତୀର ଝିଅ।
He is not an eyewitness to the occurrence.
No, madam. Disbelieved by the court.
Oh, disbelief. So now the only eyewitness to the occurrence is the injured,
Yes.
PW11,
Yes.
right? So what were the charges framed against you?
302 and 307.
302 for committing murder of that deceased Kuber Bhagarti,
again.
right?
Yes.
And 307 is for stabbing that PW11.
11.
All right. So now you come to the best witness examined is that injured PW11.
11.
Please
Deposition
place it.
but 50.
Yeah.
I know the accused and the deceased. The occurrence took place about 2 years back in the month of Baisakh at about 4 p.m. on a Saturday. On that day, while I along with PW2, the deceased, and my daughter Udya were coming to Maharapalli Chowk to board the bus. At that time, the accused rushed towards us with his brother Ananta Nirakara and mother Tara. Thereupon, the accused asked us to return back to the village, and on our dinner, he pushed his knife on my left side chest below the breast. At that time, when I attempted to catch hold of his knife in order to protect myself, I had sustained a cut injury on my palm. At that time, when the deceased tried to rescue me, the accused dealt knife blow on his belly. Thereafter, while the deceased was trying to run away towards Harijana Basti, he fell down after crossing the road and died. Then I informed the matter to some person present near the chowk. I was sent for medical examination on police requisition. I was residing the village cross-examination. I was residing in the village Maharapalli about 4 to 6 months prior to the occurrence. I had the 3 daughters, out of whom one was married by that time. The marriage proposal of my daughter Udayan had not been initiated then. There was no proposal for marriage of the accused with said Udayan. The accused never used to pay visit to our house. I had no prior acquaintance with the accused, who was living in the village Buddai. He had no enmity with me, much less any land dispute. I was not examined by the IO in connection with this case. I am narrating about the occurrence today in the court for the first time. It is not a fact that I was examined by IO and had made the statement marked X before him. It is not a fact that that as I had proposed to perform the marriage of the accused with Udayan, he was staying in our house, like an illegitimate son-in-law. One day prior to the occurrence, I had been to call my brother, deceased PW2, and my son-in-law Shiva, to inform them that I would not stay in the village anymore, but no meeting could be held in our village on that day. It is not a fact that in the meeting held in our village on the occurrence day, though I had agreed to perform the marriage of Udyan with the accused, but I had asked for 1 month time. It is not a fact that I have not made a statement to that effect before IO. Village Maharapalli is situated to the east, whereas the school is to the west. Maharapalli Chowk is situated in the north, and the road leading to Balangir is situated to the south. There is a beach road in between the Maharapalli village and the school. The said school is at a distance of about half a mile from the Maharapalli village. The Harijana Basti is situated to the eastern side of the school at a distance about 50 cubit therefrom. The meeting was held 1 or 2 hours before, and we come to our house from the place of meeting. Then proceed to Maharapalli Chowk. At that time, many people had gathered at Harijan Basti. The Harijan Basti is situated at a distance of about 100 yards from village Maharapalli. We had no talk with the accused and the person accompanying him while coming to Maharapalli Chowk through Harijana Basti. We had also not apprehended any trouble from their side on the way. 4. I was assaulted by the accused in the Harijana Basti. The deceased was also assaulted in that place. It is not a fact that I have stated before IO that the occurrence took place near the boundary of the school to court. The boundary of the school is at a distance of about 30 to 40 cubit from Harijana Basti. Cross examination. I cannot say if Harijana Basti is at a distance of about 200 cubit from the school boundary. Some dome people of Harijana Basti had surrounded me by the time of knife assault of my person by the accused. The accused had dealt 1 knife blow only to me on my left side chest. I did not sustain any injury on my body. Body. It is not a fact that I had made the statement marked X before I was incensed till I reached Maharapalli Chowk, whereafter I became unconscious. I was facing towards the Harijana Basti when the accused came from the Basti and assaulted me. I had tried to catch hold of the knife of the accused after the withdrawal of some from my body. The deceased was present by my side by the time of assault of my person. The first knife blow was given to the deceased in the Harijan Basti itself. I cannot say about the total number of knife blow given by the accused to the deceased, but he had dealt knife blow by pushing him to the other side of the road. It is not a fact that I have stated before you that the accused had pushed the deceased up to the boundary wall of the school where he stabbed him. The deceased had fallen near the boundary of the school. The deceased had died near the threshold of the Harijana Basti. The deceased had died at the very spot where he had received the injury. It is not a fact that no such occurrence had taken place near Harijana Basti. The accused had initiated the knife blow on the deceased near the school gate and punished him up to the threshold of the Harijana Basti where he died. There were stains of blood in a line at that place. I had regained my sense at Maharapalli Chowk after butter was administered to me. The accused, along with his brother and mother, had chased us. As because I had refused to give my daughter in marriage with the accused. It is not a fact that I had not stated before the High that the mother and true brother of the accused had chased us along with the accused. I cannot say on which part of his body the deceased had received injury. The accused had no prior enmity with the deceased. The deceased had also no prior acquaintance with the accused. It is not a fact that the accused had neither assaulted me nor the deceased, and that the deceased had died due to fall on the rock surface, and that I am deposing falsely.
So, even if, let us say that PW12 evidence has been disbelieved by the London trial court on the ground that it was her statement before police that by the time of her arrival, the appellant had also already assaulted or stabbed PW11 and the deceased. That means she is a post-occurrence witness.
Yes, ma'am.
But how did you do you get over the evidence of the injured witness? Because injured witness presence at the spot cannot be disputed. She herself was present and sustained injury, and she has further stated as to how not only she received injury but also the deceased received the injuries. And she specifically implicated you that you, by means of a knife, dealt blow to the belly of the deceased. And the doctor who has conducted post-mortem examination is PW8, and she has noticed a penetrated wound at page 45 of the paper book, which a part of the lung was protruded with pleura. On cutting of the lung from this spot, it was found to be a wound with clean cut margin at the center pertaining to the chest, situated over the left side chest 6 cm above the axillary fold level, so and so. And he has stated that the injury antemortem in nature, cause of death of the deceased was shock and hemorrhage due to the injury to the vital organ like heart and lung, and it is homicidal in nature. And then that knife was seized, and it was sent to the doctor, and he opined that the injury on the deceased was possible by the knife. And further stated in the cross-examination that injury number 3 will cause instantaneous death. So why we will disbelieve the evidence of this injured eyewitness PW11?
Well, the knife was seized, but the knife was seized, my lord. But there is no seizure witness is there. My lord.
No. Knife seizure witness, the IO must have stated about this. So the IO has stated that I seized a knife, so and so, so and so. This knife was seized from the spot,
Yes, my lord.
right? So that is exhibits 3 and 4. 3 and 4 bar karo exhibits likhiyo. No, 3 no 4 ko bar karo. Roktobija mati and Namuna mati. ये वाला knife ro से कवर्ड बंद करो.
କହିଦିଅ ବାହାର କହିଦିଅ ଟିକେ ଆସ୍ତେ କଥାବାର୍ତ୍ତା
ସେ ଡୋର କ୍ଲୋଜର ଟା କାମ କରୁନି.
କହିଦିଅ ବାହାରକୁ ଯାଇ କହିଦିଅ ପାଟନ
ସେ ଡୋର କ୍ଲୋଜର ଟା କାମ କରୁନି, ତାକୁ ଡାକିକି ନିଅ. That knife was seized as per seizure list exhibit 7, and the place of seizure has been mentioned to be from the house of accused Panchanan. गोटे लुहार छुरी काठ किछि लागि थाई छुरी रे तथा काठरे रक्त लागि थाई. छुरीर लंब होउची 36 cm. So this yes, prove that seizure list. So let us say that the independent witnesses to this seizure list has not supported the prosecution case. There are two witnesses to the seizure
Yes,
of this exhibit 7. They are one Pavitra Bag, the other is Kaleswar Kalkai or not. Say Pavitra Bag has been examined as PW7. Has he not stated anything about it?
मतलब P2 4 5 6 7 and 10 hostile.
The hostile matter.
7 पवित्र बाग नहीं. अच्छा आ बाकी होला कालेश्वर काक्षी गोटा की गोटा she is PW6. Okay, they have not supported the prosecution case. It's all right,
Yes.
but why will disbelieve the evidence of the investigating officer so far as the seizure of the knife is concerned? And that knife was seized and it was sent to the doctor. The doctor examined it and gave his opinion that the injury which was sustained by the deceased is possible. Not only that, the knife was sent for C examination, and human blood of group A at page 70 is the C report that was found on it. And the medical examination report of PW11 has not been proved.
8.
No,
PW
PW8
8.
is the doctor who
No,
conducted
PW11 is
postmortem
yes,
exam.
yes, ma'am.
Uh,
Yes, my lord. PW11 is not proved by the doctor, my lord. The accused also examined by the IO. IO sent for examination, and that is an report is on page 60, my lord.
Mr. Das, the doctor who examined this PW11, he has not been examined.
No.
And that medical examination report of PW11 that has been proved or not proved.
That has been proved by my lord.
Dr. Umakanto Barhia is the doctor who examined PW11. He has not been examined. But that request exhibit 8 বার কলে exhibit 8 টা দিও या ना होची PW11 ना होची बेलमती बाग
Belamati Bagh.
ବେଲମତିର ଅଛି ରିକ୍ୱେସନ ଅଛି 29/4/2001 ରିକ୍ୱେସନ ଅଛି ଏବଂ ରିପୋର୍ଟଟା ବି ଅଛି but that has not been marked. Perhaps the doctor was not available.
Exhibit 8, my lord. That is exhibit 8.
কোটা
Your injury report of the Belamoti. 8/1.
8/1 exhibit 8 এটা কি প্রমাণ করেলা
IO.
আচ্ছা let us see that IU ଆପଣଙ୍କର ହଉଛି PW13 ତ
13.
My lord.
but he is not the competent witness to prove this document.
My lord.
He
So far
can
the injured is concerned.
he can at best prove that requisition part
Requisition part and
which he has proved
My lord.
exhibit 8
My lord.
but तार अन्य साइड रे रहिची रिपोर्ट टा
My lord.
ए देखिए से जो ये exhibit 8 টা এটাকে সে প্রমাণ করেছে exhibit ট্রান্সলেটর আইও নিজে লিখিছে কিন্তু এই রিকুয়েশন হলা বেলমতি PW11 বেলমতির ইয়েটা হচ্ছে রিপোর্টটা হচ্ছে ডক্টর উমাকান্ত assistant surgeon. This has not been proved. And it is to be proved by that doctor, that the author of this. It has not been, it has been due to mark 8/1. He received, but the competent witness is the doctor. Doctor examine helani. Is he dead or এটা order sheet ରେ ସେ ବିଷୟରେ କିଛି ଉଲ୍ଲେଖ ଅଛି କଣ ପାଇଁ
check କରନ୍ତୁ।
punctured wound so and so stab wound ଅଛି? All right, that's another thing. But how did you get over that so far as the deceased is concerned? About the assault on the deceased?
My lord, there is a sudden provocation.
What sudden provocation?
ସେ ଦି ଜଣଙ୍କର ଗଣ୍ଡଗୋଳରେ ସେ ମଝିରେ ପଶି ଆସିଲେ.
No, he was a
There is
mediator.
no
Like,
previous enmity.
he was a mediator. He was.
Yes, yes, ma'am.
He had personally had no. The appellant had no enmity with the deceased.
Yes, ma'am.
The appellant wanted to marry daughter of that PW11 who has been examined as PW12. So though assurance was given by PW1, but there was some kind of delay and the accused was insisting for early marriage, for which there was dissension. And then he says, on that day, while I, along with PW2, the deceased, and my daughter, it was the chief examination author asandu, hard line. On that day, while I, along with PW2, the deceased, and my daughter, 4 persons, were coming to Maharpali Chowk to board the bus. At that time, the accused draws towards us with his brother Ananta Nirakar and mother Tara. Thereupon, the accused asked us to return back to the village. And on our denial, he pierced the knife on my left side chest. At that time, when I attempted to catch hold of his knife in order to protect myself, I sustained cut injury on my palm. At that time, the deceased tried to rescue me. The accused dealt knife blows on the belly. Thereafter, while the deceased was trying to run away towards so, he fell down. Okay, you come to page number 15. 1, 2, 3, 4, 5, 6. 6 lines from the top, page 50. The meeting was held 1 to 2 hours before, and we came to our house from the place of meeting and then proceeded to Maharpali Chowk.
Page
Page 50.
50 madam.
55 lines from the top of that page.
Yes. The meeting was held on 1 to 2 hours before, and we come to our house from the place of meeting and then proceeded to Maharapali Chowk. At that time, many people had gathered at Harijana Basti. The Harijana Basti
You see, another line, important line is page number ta purbo page tar dekhantu. Jota paragraph 3 ଅଛି 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 lines from the bottom of that paragraph. One day prior to the occurrence, I had been to call my brother. Tar bhaita hochi se deceased. PW2 and my son-in-law, Sibo, to inform them that I would not stay in the village anymore. So, ତାପରେ ଇଏ ହଉଛି ତା ପୂର୍ବ ଦିନ ଘଟା ତାପରେ ସେଦିନ ଘଟଣା ଦିନ ଗୋଟେ ମିଟିଂ ହେଲା ମିଟିଂ ପ୍ଲେସ୍ ରୁ ସିଏ ତାଙ୍କ ଘରକୁ ଗଲେ ତାପରେ ସେ ମାହାରପଲ୍ଲୀକୁ ଛକକୁ ଯାଉଥିଲେ ଏଇ ସମୟରେ the appellant came and asked them not to go away, return to the village. କାରଣ chief ରେ ଅଛି that thereupon the accused asked us to return back to the village, and on our denial he pierced the knife PW11 ku tapre. Then the deceased intervened and that knife blow was given.
PW12, who is also an eyewitness to the occurrence, why she was disbelieved?
It is notified that I have stated before the IO that by the time of my arrival, the accused have settled IO barrier from IO. That means he is a post of she is IO Tauchi, IO Tauchi PW13.
Page 55.
Page 55 ro se line ta kodi bharla page PW12 ro
59 para 7.
PW12 has stated with me that by the time of his arrival, page 59, paragraph 7. PW12 has stated before me that by the time of our arrival, the accused had already stopped PW11 and the deceased. ତେଣୁ ସିଏ ତାମାନେ ଆଇଓ ପାଖରେ କହିଥିଲା ଯେ ସିଏ ଯେ ପୋଷ୍ଟ କରା ଏଠି ଆଇ ୱିଟନେସ୍ ହିସାବରେ ଡିପୋଜ କରୁଛି
Yes, stated during the person that I am not stated so
but that has been proved to the IO. So her statement is that the police that she is a post of for the first time is telling that I am an eyewitness to that. That is the reason why our evidence has been is being that I am an eyewitness.
That's true.
Mother,
my daughter, the deceased. We went to the hospital.
All right. The mother's evidence. So how do you bring it within the case of grave and sudden provocation? ଧରନ୍ତୁ ଆପଣଙ୍କର accused ଚାହୁଁଥିଲା ସେ PW12 କୁ ବାହା ହବା ପାଇଁ। ଏମାନେ ଡିଲେ କରୁଥିଲେ ତାର ପରିବାର ଲୋକ, ସେଥି ନେଇକିନି ତାଙ୍କ ଭିତରେ ଡିସ୍ପ୍ୟୁଟ ଥିଲା ଏବଂ ଏଇ ଡିସ୍ପ୍ୟୁଟ ଯୋଗୁ PW11 ଆଉ ରହିବାକୁ ଚାହିଁଲାନି ସେଇ ଯୋଉ ଗାଁରେ ଯୋଉଠି ରହୁଥିଲା। ତେଣୁ ସେଇଥିପାଇଁ ଘଟଣା ଦିନ ଗୋଟେ ମିଟିଂ ବି ହେଲା। ସେ ମିଟିଂ ପରେ ସିଏ ତାର ଝିଅ ଅର୍ଥାତ୍ ଯାହାକୁ ଆपेଲାଣ୍ଟର ବାହା ହବାର ଥିଲା, ସିଏ ଏବଂ ଡିସିସ୍ଡ ଏମାନେ ସବୁ ସେ ଗାଁ ଛାଡିକିନି ଯାଉଥିଲେ, ଫେରି ଯାଉଥିଲେ। ଇଏ ଆକ୍ୟୁଜ ଯାଇକିନି ବାଟରେ ତାଙ୍କୁ ଦେଖା ହେଇଛି ଏବଂ ଦେଖା ହେଇକିନି ସିଏ ଇନସିଷ୍ଟ କଲା ଯେ ନାଇଁ ତମେ ଯାଅନି, ତମେ ପୁଣି ଗାଁକୁ ଫେରି ଆସ। ଏଇ ବିଷୟ ନେଇକିନି ସେ ପ୍ରଥମେ ଆଗେ assaulted this PW11 and then he sustained the injury and then the assault was made to the deceased by knife and on the vital part of the body, and that is the cause of death and it was possible by that
knife.
बाकी जो दीटा इंजुरी अच्छी, those are not related to the knife injuries because those lacerated wound might be possible by on account of fall. Injury number 1 and 2 जोड़ा की left side forehead रे अच्छी गोटे छोटो 1 inch रो injury आ गोटे रही ता palm रे. So it means that single blow has been given by the knife. And you have brought out on record that there was no previous enmity between the appellant and the deceased. And he was assaulted because he intervened when the appellant tried to or assaulted PW11. So how many years you have they are in custody?
2000.
Huh?
2001 to 2011.
Release on bail on 19/5/2011.
11.
No, you are taken into custody on what day? First, a final form of it. Charge sheet marle eta khulche. So the date is right. It is yana hochi Panchanan.
Panchanan.
So date of custody is 30/4/2001. ଆପଣ ଟ୍ରାଏଲ କୋର୍ଟରେ ବେଲ୍ ରେ ନଥିଲେ?
I do not know, madam.
ଦେଖିଦେବା। ଲେଖିଛନ୍ତି। Also submit the application with language in custody from the date of arrest, that is 3/4/2001, and have served more than 10 years. Produced on the form. Just to verify करिया भाई. Accused is produced in custody. So if केबे बेल हला 19/5/2011. It is 10 years, right? Yes, Mr. So
Period 2 also correlate to the evidence of the period 11, my lord.
But it's a single blow and there was no previous enmity, my lord. And 304 part 1 period number 1 for the PW8. Eta hochi gote penetrating one, aro dita hochi lacerated one 1 inch সেটা হচ্ছে এই যে পড়িগলা পরে সিভিয়ার নট নাইফ ইঞ্জুরিজ lacerated সে ছুরিরে মারলো না সিঙ্গেল ব্লো মারছি চেস্ট and take down JCRLA number 69 of 2008. The appellant Panchanan Udurkaruan faced trial in the court of Lennon Sessions Balangir in Sessions case number 133/B of 2001 for offences punishable under section 302 and 307 of the Indian Penal Code on the accusation that on 28th April 2001 at about 4 p.m. at village Maharpalli under Balangir Sadar Police Station, he committed murder of Kuber Bagarti, hereafter the deceased, so also stabbed Srimati Belamati Bag, bracketed PW 11, with a knife on her stomach with an intention to commit her murder. The London Trial Court, by judgment and order dated 18th March 2006, found the appellant guilty of both the charges and sentenced him to undergo rigorous imprisonment for life under section 302 of the Indian Penal Code and to undergo RI for 5 years and to pay fine of rupees 2,000, in default to undergo RI for 1 month under section 307 of the Indian Penal Code, and the sentences were directed to run concurrently. The prosecution case, as per the first information report lodged by S.K.SAHOO, bracketed PW2, on 29/4/2001, before the officer in charge of Balangir Sadar Police Station, in short is that PW11 was the daughter of his friend and she was given in marriage to an Dolagonjian bag of village Jagalpat. And accordingly, PW2 had family relationship with PW11, 4 to 5 years prior to the date of lodging of the first information report, the husband of PW11 expired, for which PW11 came to stay at village Maharpalli in the house of one Pavitra Bag, bracketed PW7, with his daughter Udia, bracketed PW12, and she was sustaining her livelihood working as a laborer. It is further stated in the first information report that 6 months prior to the lodging of the first information report, the appellant gave a proposal for marriage with PW12. And accordingly, the appellant was visiting the house of PW11 and was also looking after the well-being of PW11 and PW12. When the appellant insisted for early marriage with PW12, PW11 wanted to defer it, for which a dispute arose, and PW11 came to the village of the informant, bracketed PW2, and called PW2 and the deceased to Maharpali to solve the dispute. On 27/4/2001, PW2 and the deceased came to village Maharpali, but the matter could not be solved in the meeting. And again on 28/4/2001, another meeting was convened, and the brothers of the appellant were present in that meeting, However, the appellant was not present and since the dispute could not be sorted out on account of absence of the appellant, comma, PW2 along with PW11 and the deceased were proceeding to Maharpally Square to go to village Gungutipalli by bus. On the way, PW2 went to attend call of nature and PW11 along with his brother, bracketed the deceased, were coming and it was 5 o'clock in the afternoon. And at that time, PW11 came near PW2, receiving injury on his belly and disclosed before PW2 that she was stabbed by the appellant. And the appellant also stabbed the deceased, for which the latter was lying in front of the school at village Harijan Pada. PW2 took steps for admission of PW11 in the hospital, who was in a critical condition, and then came back to the front of the school where the deceased was lying dead with bleeding injuries. Information was given to the Balangir Sadar police station over phone, and the police officials arrived at the spot and on the verbal report of PW2, the FR was drawn off by PW13, Kishore Chand Kumar Panigrahi, the officer in charge of Balangir Sadar police station. And Balangir Sadar PS case number 56 dated 29/4/2001 was registered under section 302-307 of the Indian Penal Code against the appellant. PW13 took up investigation of the case, and during course of investigation, he examined the witnesses, visited the spot, seized the articles as per seizure list exhibit 3 and 4. He also seized a knife from the house of the appellant after the appellant was taken into custody and at his instance. The dead body was sent for post-mortem examination and the wearing apparels of the deceased were seized. After conducting inquest over the dead body, the dead body was sent for post-mortem. The investigating officer PW13 made a query to the doctor who conducted post-mortem examination by sending the seized knife regarding possibility of injury sustained by the deceased with such weapon and received the report. He also sent the seized articles for chemical examination through the learned SDGM, Balangir, and received the report, C report kardun. And on completion of investigation, he submitted charge sheet on 18/8/2001 under section 302-307 of the Indian Penal Code against the appellant. Next para, after submission of charge sheet, the case was committed to the Court of Session, complying the due procedure where the London Trial Court framed charges as aforesaid against the appellant, to which he pleaded not guilty and claimed to be tried. Accordingly, the sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined 14 witnesses, quote them, the witnesses. The prosecution also exhibited 16 documents, quote them. 7 material objects were also proved by the prosecution, mentioned them. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold that in view of the evidence of the doctor, bracketed PW8, and his report, bracket exhibit 5, and the opinion given that the injuries sustained by the deceased were antemortem in nature and probable cause of death of the deceased was due to shock and hemorrhage on account of injuries to the vital organs like heart and lungs, there could be no room for doubt that the death of the deceased was homicidal. The Lennon trial court disbelieved the evidence of PW12 as an eyewitness to the occurrence in view of our contradictory statement made before the investigating officer. However, the Lennon trial court accepted the evidence of PW11, the injured and the corroboration of our evidence from the post-mortem report and particularly the opinion which has been given by the doctor that the injuries sustained by the deceased were possible by the knife seized and the manner in which the appellant assaulted PW11 and came to the conclusion that the prosecution has been able to establish the charges under section 302 and 307 of the Indian Penal Code against the appellant beyond reasonable doubt. Ms. Tapaswini Sinha, Land Counsel appearing for the appellant, contended that since out of the two eyewitnesses examined by the prosecution, the evidence of PW12 has been disbelieved by the Lennon trial court, the case of the prosecution rests upon the solitary evidence of PW11. According to Ms. Sinha, the evidence of PW11 cannot be said to be absolutely reliable and truthful, so that implicit reliance can be placed on our evidence. It is argued that even though PW11 stated to have sustained injury on account of knife blow given by the appellant on her left side chest, and according to the investigating officer, she was sent for medical examination. But the doctor who examined PW11 was not examined during trial to prove the injury report, and such report has been proved by the investigating officer. The learned counsel argued that PW13 is not the competent witness to prove such report in absence of any material on record as to why the doctor could not be examined to prove such report. And more particularly when the defense is did not get any opportunity to cross-examine the doctor, and therefore it is difficult to sustain the charge under section 307 of the Indian Penal Code. It is further argued that there was no previous enmity between the appellant and the deceased, and the occurrence happened all on a sudden when PW11 along with the deceased were trying to leave the village where they were staying and to proceed to Maharpali Chowk to catch a box, and the appellant intervened and requested PW11 to come back to village Maharpali, and since the deceased intervened, on account of grave and sudden provocation, a single blow was given to the deceased, which proved fatal. And in view of the background of the case and the surrounding circumstances under which the assault has been made, it may be a case of culpable homicide not amounting to murder, punishable under section 304 part 1 of the Indian Penal Code, but not under section 302 of the Indian Penal Code. The Land Council further argued that the appellant was taken into judicial custody on 30/4/2001, and he was never released on bail during trial. And after this jail criminal appeal was preferred, he was directed to be released on bail as per the order of this court on 19/5/2011. And as such, he has remained in custody for more than 10 years. And therefore, the conviction may be altered to one under section 304, part 1 of the Indian Penal Code, and the sentence be reduced to period already undergone. Mr. Orupananda Das, an additional government advocate, on the other hand, supported the impugned judgment and argued that since the appellant was insisting for early marriage with PW12 and PW11 was not agreed for the same, there was dispute between the parties and a meeting was convened on the date of occurrence at village Maharpali. Were liking each other, but subsequently the mother decided to perform her marriage elsewhere. That might be the cause. But strangely enough, people were stated in her evidence report that if she didn't know, she didn't know. A meeting was convened on the date of occurrence at village Maharpali. And since the appellant didn't attend the meeting, no settlement could be arrived at. And while PW11 and the deceased and his brother, deceased, were leaving the village and proceeding towards Maharpali Square, the appellant appeared on the scene of occurrence and not only assaulted PW11 but also dealt a blow on the chest of the deceased, for which the deceased made instantaneous death. The London Council argued that in view of the postmortem report, which has been proved by PW8, the ocular evidence adduced by PW1 is getting corroboration from the medical evidence. And since the deceased, being the brother of PW11, intervened when the assault was made to PW11 by the appellant, the manner in which the deceased was assaulted at the spot, and the effect of the blow which was given by the appellant on the chest clearly proves that the appellant intended to commit murder of the deceased. And therefore, the London Trial Court has rightly found the appellant guilty under section 302 of the Indian Penal Code. The petition to pursuant to the public prosecutor. In the said petition, the prayer has been made for marking the injury issued by Dr. Swanso as an exhibit. In that connection, prosecution has relied upon a decision reported in Swanso and verification of the decision would have happened volume 95, 2003, Court of Law Times, 477. On verification of the case record, it is revealed that SR of summons issued against Dr. Uma Kanto Baria, the Director of Health Service, Orissa, returned answer with a report that he, having resigned from the service, has joined Indian Navy. In this case, the sole accused Panchanan Swanso is all along in jail custody in the above promises and impure the principle and vice within the aforesaid decision. I am inclined to allow the petition. Accordingly, the injury report of Swanso issued there is marked as Swanso. Prosecution cases. All right, कौन लिख ले? And so also under section 307 of the Indian Penal Code, as in spite of best attempts made by the prosecution, the doctor could not be produced, and on the prayer made by the public prosecutor, the injury report of PW11 was marked as exhibit D by 1 as for the order dated 12/1/2005. Adverting to the contention raised by the learned counsel for the respective parties, let us first see whether the prosecution has successfully established that the deceased met with a homicidal death, deceased Kuber Bagarti met a homicidal death or not. PW13, the IO, held inquest over the dead body and prepared the inquest report, Exhibit 1, a exhibit of Harpalan. At the spot, and the dead body was sent for post-mortem examination, and PW8, the assistant surgeon attached to DHH Balangir, conducted post-mortem examination on 29/4/2001, and he noticed the following injuries. A page number 45 quote kar debe tinta injury. Jahan lekha hai se paragraph ta entire likhe debe. The cause of death was so and so. After seizure of the knife from the house of the appellant, the investigating officer sent it to PW8, seeking for his opinion whether the injury sustained by the deceased was possible by such weapon or not. And PW8 has opined that the injuries on the deceased was possible by such weapon. And the report has been marked as Exhibit 6. In the cross-examination, the doctor has stated that injuries number 1 and 2 were possible by fall on the rough surface. However, he has stated that injury number 3 would cause instantaneous death. Nothing further has been elicited in the cross-examination, and the learned counsel for the appellant has also not disputed regarding the homicidal death of the deceased. And therefore, we are of the humble view that the learned trial court has rightly come to the conclusion that the deceased met with homicidal death. During trial, the prosecution examined PW11, Belmoti Bagh, and his daughter, PW12, Udia Bagh, as eyewitnesses to the occurrence. The learned trial court, after assessing the evidence of PW12, came to hold that PW12 disbelief juta korche খুব পারে is internet page 6. Exhibit 16 constituted. That the attention of her previous statement made before the IO has been confronted to PW12 that she has not stated to be an eyewitness to the occurrence, and that she has stated before the IO that by the time of her arrival, the appellant had already stabbed PW11 and the deceased. The previous statement of PW12 was that she was liking the appellant and her mother bracket PW11 had fixed off her marriage with the appellant. But subsequently, PW11 decided to perform her marriage elsewhere. But strangely, PW12 stated in her evidence in court as if she did not know the appellant. The Lennon trial court held PW12 to be not a reliable and trustworthy witness. We are of the humble view that since PW12 did not state before police to be an eyewitness to the occurrence, and gave her statement as a post-occurrence witness, her evidence in court that she was an eyewitness to the occurrence and had seen the assault not only on PW11 but also on the deceased has been rightly disbelieved by the Lennon trial court. If the evidence of PW12 is discarded, the only evidence remains to be an eyewitness to the occurrence is PW11. PW11 has stated that on the date of occurrence, she along with PW2, the deceased and PW12 were proceeding towards Maharpali Chowk to board a bus. And at that time, the appellant rushed towards them with his brothers and mother and asked them to return back to the village. And on their denial, he pierced his knife on his left side chest below the breast, and she attempted to catch hold of the knife in order to protect herself, for which she sustained injury on her palms. And at that time, the deceased tried to rescue her, but the appellant dealt knife blows on the belly of the deceased. The deceased was trying to run away towards Harijan Basti, but he fell down after crossing the road and died. In the cross-examination, PW 11 has stated that the appellant never paid any visit to their house, and she had no prior acquaintance with the appellant. And she had no enmity with the appellant, much less any land dispute. She further stated that one day prior to the occurrence, she had been to call her brother, bracketed deceased, PW2, and inform them that she would not stay in the village anymore. She further stated in the cross-examination that a meeting was held 1 to 2 hours before they left the village, and they came to their house from the place of meeting, and then they proceeded to Maharpali Chowk. She further stated that she was assaulted by the appellant in Harijan Basti, and the deceased was also assaulted in that place. She specifically stated that the appellant dealt one knife blow to her on the left side of chest, and she tried to catch hold of the knife of the appellant after he withdrew the same from the body. From the evidence of the investigating officer, bracketed PW 13, it appears that PW 11 was sent for medical examination, and the requisition has been marked as Exhibit 8. It appears from the medical examination report of Belmati Bagh, Exhibit 8, that Dr. Umakanto Behera examined her on 29/4/2001, and he noticed a stab wound on the medial aspect of her left breast of size 1 inch into half inch into 1/2 inch, which was opined to be simple in nature. Another stab wound on the left side of the chest of size 3/4 inch, 1/4 inch, 1/4 inch, which has also been opined to be simple in nature, and 3 simple injuries, incised wounds on the little finger, right finger, and middle finger of the right hand, which are also opined to be simple in nature. It's correct that the doctor who examined PW 11 on police requisition could not be examined, and therefore exhibit 8/1 could not be proved through him, but it has been proved by the investigating officer bracketed PW 13. The order dated 12/1/2005 of the London Trial Court indicates that a petition was filed by the London Public Prosecutor on 5/10/2004 for marking the injury report issued by Dr. Umakanta Baria in favor of PW 11 as an exhibit. The London Trial Court verified the case record, which revealed that SR of summons issued against the said doctor through Director of Health Services Odisha was returned back unserved with a report that he, having resigned from his service, had joined Indian Navy. Since the appellant was in jail custody since 30/4/2001, and there was delayed disposal of the case, the London Trial Court allowed the petition filed by the public prosecutor, relying on the ratio laid down by division bench of this court in case of Basu Harijan versus State of Orissa, reported in volume 95, 2003, Cuttack Law Times, 477. Wherein it was held that non-examination of the doctor who conducted autopsy on the ground that his attendance could not be procured for his evidence, and since the report has been marked on the consent of the defense, the autopsy report could not be brushed aside. Therefore, we are of the view that even though the doctor could not be examined before the London trial court, as per the reasons assigned by the London trial court in its order dated 12/1/2005, since the report has been marked as Exhibit 8/1 without objection, and it cannot be said that in any way the appellant has been prejudiced for the non-examination of the doctor, and more particularly when the said order passed by the London trial court has not been challenged in the higher court. The London trial court has rightly placed reliance on the injury report of PW11 marked as Exhibit 8/1. However, looking at the injury sustained by PW1 as per the injury report Exhibit 8/1, it appears that all the injuries were simple in nature, and there is nothing on record that any of the injuries are fatal. And therefore, we are of the view, taking into account the ratio laid down by the Honorable Supreme Court in case of 1968 SCD 20/8. It is the conviction under section of the appellant under section 307 of the Indian Penal Code is not sustainable in the eye of law, and the conviction is altered to one under section 324 of the Indian Penal Code. The evidence of PW11 has not at all been shaken in the cross-examination. However, it appears that there was no previous enmity between the appellant and the deceased. The occurrence happened all on a sudden, when without intimating the appellant, the PW11 along with the deceased and PW2 were leaving the village and proceeding towards Meherpali Square. And when the appellant came to know about the same, he came and requested them to return back to the village, to which PW11 didn't agree. The possibility of a dispute arose at that point of time between the parties cannot be ruled out. And when the appellant assaulted PW11 first, the deceased intervened, and it appears that a single blow was given with the knife on the chest. And which proved to be fatal. Law is well settled that merely because a single blow has been given, that would not ipso facto bring the case from section 302 of the Indian Penal Code to either under section 304 part 2, part 1 or part 2 of the Indian Penal Code. But taking into account absence of any previous enmity, the surrounding circumstances under which the offense has taken place, and the single blow given by the appellant, we are of the view that the case would fall squarely under the exception 1 to section 300 of the Indian Penal Code. And as such, the conviction of the appellant under section 302 of the Indian Penal Code is altered to one under section 304 part 1 of the Indian Penal Code. It appears that the appellant was taken into judicial custody on 30/4/2001, and he was not released on bail during trial, and when he preferred the appeal by order of this court dated 19/5/2011, he was directed to be released on bail, and as such, he has undergone more than 10 years of substantive sentence. The occurrence took place in the year 2001, and more than 22 years have already passed, and the accused is enjoying his liberty for more than 12 years by now. And therefore, while convicting the appellant under section 324 of the Indian Penal Code, we sentence him to undergo RI for 1 year, and for the offense under section 304 part 1 of the Indian Penal Code, we sentence him to undergo RI for 10 years, and both the sentences are to run concurrently. Since the appellant has already undergone the sentence as imposed by us today, he shall not be taken into judicial custody further. Accordingly, the jail criminal appeal is allowed in part. Put a note of appreciation on the Ms. Sinha and also Mr. Das, whether you are engaged as amicus curiae or
No, my lord, this is a case of Rajendra Kumar Sinha's case.
okay. No, that means you have not been engaged by this court. All right, then leave it like.
So this is a legal aid case, my lord. This is a legal aid case and case to Rajendra Kumar Sinha.
Okay, that usual fee you will get from, but if you would have engaged you as amicus curiae, then matter would have been different. You would have asked for payment, but now the usual fees which is legal aid is giving to the council engaged, that you will get. Okay.
Pardon, mention my lord, bail matters, my lord.
Tied up bail matters and criminal appeal, my lord, JCRL or bail.
My lord, kindly mention for JCRLA. The petitioner is in jail for about 8 years.
Please give.
My lord, one JCRL custody more than about 7 years, your lordship.
May I beg to pardon, my lord. This matter was specifically urgent to 16(1), my lord. Not listed, my lord. SC/ST appeal, my lord. SC/ST appeal, my lord.
Tied up. Two criminal appeal for bail. Tied up bail. Tied up bail. There is criminal appeal and two tied up bail matters.
My lord, it was direct to listed 16, but could not have been listed.
What is the matter?
ST/ST.
Pardon to make mention, your lordship. My lord, this is criminal revision 172/2023, my lord. My lord, is the petition challenging the rejection of charge, my lord. By this is charged by the London trial court, my lord.
Discharge petition was rejected.
My lord, my lord.
Give
My
it
lord, and my lord, already 15 years has been passed, my lord. Till date, already 15 years has been passed. Till date, no trial has been started, my lord.
Please give the memo.
My lord.
Pardon, mention one CRLA, my lord, was fixed to 22nd January, my lord. But not
What is that CRLA for?
for bail, my lord.
Give it.
Assist.
My lord, this is revision for we have filed from last 3 months, my lord. It's not face admission, my lord. Criminal revision. It's not been listed yet.
Give it. Yes.
That's item number 7 of the list.
Sir, notice for delivery of order. I 16999 of CRL 797.
After carefully and meticulously analyzing the finding of the London trial court, the submission made by the London counsel for the respective parties and the evidence on record, I am of the humble view that at this stage it cannot be said that it is a case of no evidence against the petitioner. whether on the basis of the points raised by the learned counsel for the petitioner, benefit of doubt is to be extended to the petitioner, is to be adjudicated at the final stage when the appeal would be heard on merit. Giving any finding on the merits of the case is likely to cause prejudice to either of the parties. This court will certainly have a duty to make deeper scrutiny of the evidence and decide the acceptability or creditworthiness of the evidence of the witnesses at the final stage of hearing of the appeal on merit. At this stage, reappreciation of evidence by conducting detailed analysis and trying to pick up lacunas or loopholes in the case of the prosecution is not permissible. No extraordinary circumstance oblique material is shown to this court for granting the desired relief to the petitioner. Therefore, I am of the humble view that for the limited purpose of ascertaining whether stay of order of conviction be granted or not, I find that the petitioner has failed to make out a very exceptional case or special reasons for keeping the conviction in abeyance, and as such, in the facts and circumstances of the case, the relief sought for by the petitioner for staying the order of conviction cannot be granted. Accordingly, the interim application being devoid of merits stands dismissed. Yes, Mr.
Madam. May I please, madam?
Supplementary list, item number 25.
My lord, on behalf of the election petitioner, in course of their argument, certain grounds have been set forth before your lordship and urged. For rejection of the nomination and setting aside the election of the respondent. First ground is the nomination filed by the respondent is not in prescribed form 2B. Inasmuch as part 2 of prescribed form 2B has been deleted. This is one of the grounds. Second is affidavit in form 26 dated 3/4/2019 has been filed along with the nomination dated 2/4/2019. Therefore, the said affidavit is no affidavit in the eye of law, and as such, the nomination of the respondent is liable to be rejected and his election is liable to be set aside. 3 is, since the respondent has given false particulars with respect to criminal antecedents in Form 26 affidavit and did not disclose all criminal cases. I beg to emphasize on this expression in their allegation. Did not disclose all criminal cases. Of course, in course of argument, they said now all criminal cases have been, all 13 criminal cases have been disclosed. Only there are some discrepancy and differences in the description of the offences. His nomination is liable to be rejected and his election is liable to be set aside. Next is the respondent did not disclose all property details in his affidavit filed in Form 26. On the next date, this was their argument on the first day. on 11th. On 12th, they drew attention of my lord to section 33 of the RP Act, Rule 4 of the Conduct of Election Rules 1961. Their contention before your lordship was, by deleting part 2 of Form 2B and by deleting some paragraphs of Form 2B in part 3 and part 3A, the respondent has changed the format of Form 2. Therefore, his nomination is liable to be rejected and his election is liable to be set aside. My lord, under paragraph 7A, they contended respondent so moto deleted part 2 of the Form 2B in the nomination paper filed by him before the returning officer on 2/4/2019. Part 3 of Form 2B of nomination paper filed by the respondent is also not in the prescribed Form 2B. Part 3A of the nomination paper filed by the respondent has not been filled up by the respondent. And columns of Part 3A of nomination paper has been left blank, and columns from 3 to 9 are also not in the prescribed Form 2B. But our contention before your lordship was that respondent has rightly deleted part 2 of Form 2B as per the instruction given in the nomination Form 2B. To the effect, strike off part 1 or part 2 below, whichever is not applicable. We further contended that words strike off and delete are synonymous. The respondent has deleted part 2 of the Form 2B since the phrase used was a strike off. As the strike off and delete is the same, we deleted it. Then their contention was, they accepted before your lordship that yes, strike off and delete means the same in common parlance. But in election law, that does not have the same meaning. The above contention, this contention of theirs, your lordship particularly put them a question, is there any decision to that effect? They said, no, we don't have any decision to that effect. So far as part 3 and part 3A of Form 2B are concerned, they admitted in course of argument that the portions deleted by the respondent are neither relevant nor applicable to the respondent on your lordship's query. According to us, this amounts to their halting admission that the respondent has not committed any mistake with respect to part 3 and part 3A. Further, we beg to submit before your lordship that they have not cited that the respondent has concealed any information required to be given in part 3 and part 3A. No allegation, no pleading to that effect in the entire election petition. Nor in course of evidence also, they agitated this point. Now, with respect to the case laws relied upon and cited on behalf of the respondent, it was submitted by the advocate of the election petitioner that the same are not applicable to the facts and circumstances of the present case. This is the sum and substance of their entire argument and counter argument. Now your lordship is to decide and determine A, whether strike off and delete, strike out and delete, and score off and delete, score out and delete means the same or not. Because these phrases are available in the nomination form. Secondly, whether portions deleted by the respondent are relevant and applicable for him or not. That is my second humble submission before your lordship. Thirdly, whether by deleting the portion in question in nomination paper in form 2B, the respondent has concealed or not declared any information which is required to declare under law. Lastly, whether the case law, we cited case laws, two case laws. One is Ramesh Raut and another is Shambhu Prasad Sharma. Whether the case law cited on behalf of the respondent laying down the principle that any and every departure in the nomination paper is not fatal. Whether those two decisions are applicable to us or not applicable. If it is applicable, we have satisfied all the conditions.
What is that exact word? Any and every departure.
Departure in the nomination paper.
From the format of the nomination.
Nomination
is not fatal.
Is not fatal. ଆମ ଆଠଗଡ଼ କେସରେ ବି ସୁପ୍ରିମକୋର୍ଟ ସେୟା କହିଛନ୍ତି, ଶମ୍ଭୁ ପ୍ରସାଦ ଶର୍ମାରେ ବି ସେୟା କହିଛନ୍ତି.
How or in what context it was held like that? Well, the fact situation is not similar.
No. That's
so how the
ସେଥିରେ ଥିଲା କ'ଣ
you because that was not a case where this some of the parts were deleted. But it was not in that context. So
Honorable Apex Court कहले part 2 is not relevant for the candidate because he is a candidate sponsored by a recognized political.
No, that is the general thing.
Part 3 रे जोटी रहउची symbol choice टा सेटा एबे C double I हेती सेतोले B double I थिला. That is also not relevant for the candidate.
No. There are two things. What they want to say that it is not relevant is one thing. To totally delete it out from that format is another thing. In that way, they want to distinguish it.
Shambhu Prasad Sharma
form 26 रे जोटी liabilities portion टा लिखिया कथा all candidates माने से portion टा छाड़ देइथले format रे काहर नथिला तो appellant रो कहबा कथा हला जे मो nomination टा ठीक आ सब nomination टा rejected हो because it is not in the prescribed form. Honorable Apex Court कहले every departure from the format of the nomination paper is not fatal. So the departure heiti, you have again to prove that it is required to be given and the candidates have outstanding and liabilities.
That means if some information which was required to be given to the voters,
exactly,
to the public, for their knowledge so that they will judge whether to vote this candidate or not. That has been withheld or suppressed or any kind of wrong information has been given in that respect, then those things are definitely have to be taken into account and those are fatal. But if one thing is not relevant, number one, for a particular candidate and on that aspect, no information is required to be also given, then
That is
The
not fatal.
departure is not fatal.
Fatal.
That is.
That's all about 7A.
Hmm.
Now coming to 7B.
Hmm.
Side to yeah.
So it can be said in other way that this type of deletion has no way affected the voters' right to know the candidate.
Exactly.
Okay. So all relevant information which the voter
Required
has
to
a
be
right
given.
to know that has been furnished by the respondent. And whatever was not furnished, that was not given.
That
and
was not relevant.
That was not relevant.
And was not required to be.
Yes. So 7B, what do you say?
7B रे से आपको देखेले exhibit 32/5, 32/6 तांकर कथा होची affidavit dated 3/4/2019 has been filed on 2/4/2019.
Right.
Therefore, it is no affidavit in the eye of law, and as such, the nomination is liable to be rejected, and election is liable to be set aside. से आपको तीनटा exhibit देखेले exhibit 32/5, 32/6, 32/7. If your lordship for a moment look to those three exhibits, ତାଙ୍କର ବକ୍ତବ୍ୟ ହେଉଛି ଯେ affidavit uploaded on 2/4/2019 ସେଥିରେ ଗୋଟେ endorsement ଅଛି
First page.
ଆଜ୍ଞା. Whereas they have marked affidavits dated 2/4/2019 as exhibit 39/1, 40/1, 41/1 and 42/1. 2 ତାରିଖର affidavit ଟା ବି ସେ ନିଜେ exhibit ମାରିଛନ୍ତି କରିଛନ୍ତି. So your lordship's query to the arguing counsel was, yes, on 2/4/2019 an affidavit in form 26 was filed by the respondent, and that has been marked as 39/1, 40/1, 41/1, 42/1. How do you say that affidavit dated 3/4/2019 has been uploaded on filed on 2/4/2019? They did not answer to that query. Then your lordship also they themselves have marked 4 checklists dated 2/4/2019, 39/2, 40/2, 41/2, 42/2, wherein the returning officer has given instruction to the respondent to file revised fresh affidavit before commencement of scrutiny of nomination. ସେଇଟା ବି ସେଇମାନେ exhibit କରିଛନ୍ତି. They have marked affidavit.
That checklist is one of the checklist. Hey, checklist টা দেখি.
হ্যাঁ.
Revise checklist টা গোটে কোনটো?
মানে রিভাইজ দেখলে না
ନାଇଁ ଦୁଇ ଚାରିଟା ଆଗେ
checklist টা.
ହଁ.
Checklist টা.
39/2
গোটে খালি just কোনটো? 39/2 কোন কোন? (39/1) সেটা 39/2 হ্যাঁ সেটা
ସେଇଥିରେ instruction ଅଛି.
সিরিয়াল নম্বর 1 টা দেখন্তু affidavit in form 26 দেখলে not in prescribed format column 5 6 7 8 টা are not filled up.
ତା ତଳେ instruction ଅଛି.
তারপরে item 6 पर লেখা যদি following documents have been not filed that should be filed by so and so date. তার বি রে লিখলে instruction টা দেলে.
So the use of words, according to you, the use of words revised affidavit.
Minor.
That indicates that
you file a revised affidavit.
Okay, that means it is not a case of no affidavit.
No affidavit.
It's a case of affidavit, but
file revised
affidavit, but not in prescribed
Right.
format. Columns are left blank. So arrow given instruction to file revised.
ଦିଟା ଡକୁମେଣ୍ଟ ସେ ଏକ୍ଜିବିଟ୍ କରିଛନ୍ତି. Exhibit affidavit dated 3/4/2019, they themselves have marked as exhibit. Exhibit 43, 44, 45, 46. अच्छा, checklist dated 4/4/2019, they themselves have marked as exhibit 47.
जोटा revised affidavit file पाइला परे आ गोटे checklist.
So these two documents ତାଙ୍କ ନିଜ ଏକ୍ଜିବିଟ୍ ପ୍ରୁଭ୍ କରୁଛି ଯେ 3 ତାରିଖର ଏକ୍ଜିବିଟ୍ଟା ଏ ଆଫିଡେଭିଟ୍ଟା 4 ତାରିଖ ଦିନ ଏକ୍ଜିବିଟ୍ 47ରେ ରିଟର୍ଣ୍ଣିଂ ଅଫିସର ଚେକଲିଷ୍ଟ ଦେଇକିରି ରିସିଭ୍ କରିଛନ୍ତି.
47 ଟା ଟିକେ ବାହାର କର. Restless 39/2. Then again 47. In 39/2, there is a tick mark on that small b, which is not there in that exhibit 47.
In serial number 1,
it is mentioned that yes, it has been.
If 47 लिखले all columns filled up.
ଏକ୍ଜିବିଟ୍ 47 ତାଙ୍କ ଡକୁମେଣ୍ଟ. ତାଙ୍କ ଡକୁମେଣ୍ଟ କହୁଛି ଯେ ରିଟର୍ଣ୍ଣିଂ ଅଫିସର ରିସିଭ୍ କଲେ 3/4 ଆଫିଡେଭିଟ୍ଟା 4/4ରେ.
ରେସ୍ପଣ୍ଡେଣ୍ଟ ବି ସାଇନ୍ କରିଛନ୍ତି, ଟାଇମ୍ ପକେଇଛନ୍ତି 12:20 PM ବଟମରେ ଆର ମଧ୍ୟ ସାଇନ୍ କରିଛନ୍ତି। And these documents have been called for from the custody of district election officer by their application.
ତାଙ୍କର ଗୋଟେ ଡକୁମେଣ୍ଟ ଆମେ ଏକ୍ଜିବିଟ୍ କରିଛୁ, ସେଟା ହଉଛି ଏକ୍ଜିବିଟ୍ W। ସେ ଗୋଟେ IA ଫାଇଲ କରିଥିଲେ ବିଫୋର ୟୋର ଲର୍ଡସିପ, IA ନମ୍ବର 24 of 2020। ଏକ୍ଜିବିଟ୍ W ଟାକୁ ଟିକେ ଦେଖନ୍ତୁ।
Exhibit W is a petition.
Petition filed by them. ତାକୁ ଆମେ ଏକ୍ଜିବିଟ୍ କରିଛୁ। କାହିଁକି ଏକ୍ଜିବିଟ୍ କରିଛୁ ନା ସେଇଥିରେ ସେ ଯୋଉ ହାଇପରଲିଙ୍କ୍ସ ମେନସନ କରିଛନ୍ତି, କଜ ଟାଇଟଲ ଟା ସାର୍ ଦେଖନ୍ତୁ, paragraph 4 ଦେଖନ୍ତୁ, paragraph 5 ଦେଖନ୍ତୁ, prayer portion shows that the revised affidavit dated 3/4/2019 have been uploaded on 4/4/2019।
ମାନେ ଗୋଟିଏ ଖାଲି ପ୍ରେୟାର ପର୍ସନ ଦେଖନ୍ତୁ, ସବୁ ସମାନ ଅଛି।
ତାଙ୍କ ହାଇପରଲିଙ୍କ୍
ପ୍ରେୟାର ହାଇପରଲିଙ୍କ୍ ରେ
ହାଇପରଲିଙ୍କ୍ ଗୁରା ଯୋଉ ଦେଇଛନ୍ତି, https://suvidha.eci.gov.in/uploads/SC affidavit/2019 ହଉଛି year /SC ମାନେ assembly constituency /S18 means state code, ओडिशा कोड हଉଛି S18, तापरे 2019 हଉଛି year, 04 हଉଛି month, 04 हଉଛି day, then 094823 जोटा रहिला सेटा PDF नंबर, तापर ମଧ୍ୟ ସେ ଦେଇଛନ୍ତି S18 2019 year, 04 month, 04 day, 094823.pdf। ये सब जगह लास्ट को देखंतु, खाली PDF नंबर 5टा लास्ट को 6टा बदली जाउची, किंतु 2019 4/4 से सब थे रहउची। 4टा हाइपरलिंक्स देखंतु, 4टा फिल्म
एवढा का 4 दिन अपलोड ହେଇଛି।
ଏବଂ ମାଇନର ଟିକେ ଆସିବେ, ସେଇଥିରେ ଅଛି W/2 କୁ ଆସନ୍ତୁ। W/2 ସେ ବଞ୍ଚର 3ଟା ଖଣ୍ଡେ ପେଜ ଛାଡିକି
ଫର୍ମ 26
ର ଫାର୍ଷ୍ଟ ପେଜ ଦେଇଛନ୍ତି, ସେଇ ରହିଛି ସେ ଉପରେ ମଧ୍ୟ ସେଇ ଅପଲୋଡିଂ ରହିଛି 2019/4/4 ତାଙ୍କରି ଡକୁମେଣ୍ଟ ଏଇଟା ହଉଛି ଫାର୍ଷ୍ଟ ଏକ୍ଜିବିଟ୍ 43 ଯୋଉଟା ହେଇଥିଲା ଏଇଟା।
ଏଇଟା ତ ସ୍କାନିଂ ହେଲା ବେଳେ ଜଣା ପଡୁନି, ଖାଲି ट्रू कॉपी अटेस्टेड ଲେଖା ହେଇଛି 3/4/2019 ରେ ନୋଟାରୀ ପବ୍ଲିକ
ପୁରା ଟପ ରେ ଦେଖିବେ,
ଆଉ ସେ ଉପରଟା କଟି ଯାଇଛି। ଏଠି କଣ ତା ଦେହରେ ଅଛି କି?
ଏଠି ଅଛି 2019/SC/S18/2019 ସେଇ PDF ନମ୍ବରଟା
ଆଚ୍ଛା
ଏବଂ W/4 ରେ ମଧ୍ୟ ସେଇଟା ଅଛି, ସେମ୍ ସେଇ 2019/04/04 W/4 ର ଟପ ରେ ଦେଖିବେ। ମୋର ସାର୍ଟିଫାଇଡ କପିରେ ଆସିଛି।
ଏଟା ସ୍କାନିଂ ରେ କାଟିଦେଲ କେମିତି ଉପରଟାରୁ? ଏଇ ଉପରେ ଯୋଉଟା 44
2019/04/04 then W/6 my lord ଦେଖିବେ, ସେମିତି ସେଇଆ ରହିଛି, କେବଳ PDF ନମ୍ବରଟା ବଦଳି ଯାଉଛି ଲାଷ୍ଟ କୁ, ନହେଲେ S18 2019/04/04 ଅପଲୋଡିଂ ଡେଟ୍।
ତାପରେ ଗୋଟେ କଣ ରହୁଛି 0
ସେ 0 ତାପରେ ଯୋଉ ରହିଲା 094946
ସେଟା କଣ?
ସେଇଟା ହଉଛି PDF ନମ୍ବର।
ମାନେ ଅପଲୋଡିଂ ନମ୍ବରଟା
ଆଚ୍ଛା
ସେଟା ସାରା ଭାରତ ବର୍ଷର ହଉଛି ସେ ନମ୍ବର ଆସିକି ବଦଳି ଯାଉଛି ଟାଇମ୍ ଟୁ ଟାଇମ୍। ତାପରେ ଦେଖିବେ ମାଇଲର W/8 ତାର ଏଇଟା କେତେ ଦେଇଛନ୍ତି W/8 ହଉଛି ଦି ଅରିଜିନାଲ ୱାନ୍ ସେଟା ଟ୍ରୁ କପି ଲେଖା ହେଇନଥିବ ସେଥିରେ ମଧ୍ୟ ସେୟା ରହିଛି କେବଳ ଲାଷ୍ଟ 6ଟା ନମ୍ବର PDF ନମ୍ବର ବଦଳି ଯାଉଛି 2019-0404 it is their document.
So this particular Form 26 or affidavit, this was uploaded on 4th.
2009.
Filed on 4/4, uploaded on 4th.
And the date is obviously এটা affidavit ହେଇଛି 3 ତାରିଖ ଦିନ
ଆଜ୍ଞା
ସେଟା ଜଣା ପଡୁଛି clearly.
ଆଜ୍ଞା ଆଜ୍ଞା
Okay, yes.
ତାପରେ ଏଇ ନିର୍ବାଚନରେ 90 ବାରବାଟୀ କଟକ ଆସେମ୍ବଲି କନଷ୍ଟିଚୁଏନ୍ସିରେ 2 ଜଣ କ୍ୟାଣ୍ଡିଡେଟ୍ ଡିଫେକ୍ଟିଭ ଆଫିଡେଭିଟ୍ ଦେଇଥିଲେ ଛାଡ଼ି ଦିଅନ୍ତୁ 2 ଜଣ କ୍ୟାଣ୍ଡିଡେଟ୍ ଡିଫେକ୍ଟିଭ ଆଫିଡେଭିଟ୍ ଦେଇଥିଲେ ଜଣେ ରେସ୍ପଣ୍ଡେଣ୍ଟ ଆଉ ଜଣେ ପ୍ରିୟଦର୍ଶନ ପାଭେଲ ସିଏ affidavit dated 29/3/2019 filed by candidate Priyadarshana Pavel has been marked as exhibit DP/1 which has been found as incomplete and defective by the RO. RO issued checklist dated 29/3/2019 exhibit DP/2 directing therein to file a revised affidavit before commencement of scrutiny of nomination to Priyadarshana Pavel. The candidate sworn the affidavit on 3/3/2019 at 33/2019 which was marked as DP/3, exhibit DP/3. The revised affidavit dated 30/3/2019 has been filed before RO on 4/4/2019 and after receipt of the revised affidavit dated 30/3/2019 exhibit DP/3 on 4/4/2019 the RO issued a fresh checklist dated 4/4/2019 which has been marked as exhibit DP/4. ଆଙ୍କର ଯେମିତି ହେଇଥିଲା ରେସ୍ପଣ୍ଡେଣ୍ଟର ବି ସେମିତି ଡିଫେକ୍ଟିଭ ଆଫିଡେଭିଟ୍ ଥିଲା
DP/1
ଦେଖିସାରିଲେଣି
ସେ ଦେଖିସାରିଲେ
ଖାତା ଦେଖିଥିଲେ DP/2 first checklist DP/3 second revised affidavit and DP/4 is the test checklist after receipt of the revised affidavit.
ଆ ଦେହରେ ବି ସେମିତି ଏଇଟା ଯୋଉ ସବସିକ୍ୱେଣ୍ଟ ଅପଲୋଡ ହେଲା ତା ଦେହରେ ବି ସେମିତି ପ୍ରଥମ ନମ୍ବରଟା ନାହିଁ
ସେଇଟା ମାଇଲର ଆମର ଆପ୍ଲିକେସନ ଆପଣ ଏଠି କୋର୍ଟରେ ଡାଉନଲୋଡ କରିଥିଲେ ସେଇଟା
DU
DU ଟା ଟିକେ କାଢନ୍ତୁ এটা 20/7/2023 ରେ
ଅର୍ଡର ସିଟ୍ ଡେଟେଡ୍ 20/7/2023
ରେ ଆପଣଙ୍କର ଅର୍ଡର ଅସୁବିଧା ଏଠି produced and downloaded in court.
ତା ଦେହରେ ଦେଖୁଛି affidavit uploaded 29 March 2019
ଯୋଉ ମିଳୁଛି ଦେଖିବେ ସେଠି ଯୋଉ affidavit ମିଳୁଛି ସେଇଟା DU/4 ହେଇଛି ସେଇ 30 ତାରିଖ ସେଠି 29 ତାରିଖ ଆଭେଲେବଲ
ଆଫିଡେଭିଟ୍ ନାହିଁ
ଆମ କେସ୍ ଯେମିତି ହଉଛି ସେଟା ତାଙ୍କର
ଯୋଉଟା କି ରିଟର୍ଣ୍ଣିଂ ଅଫିସର ଏକ୍ସପ୍ଲେନ କରିଛନ୍ତି subsequent affidavit overrides the earlier affidavit.
ଲିଖିଦେଲେ ନା DU ଟା
ତାପରେ Exhibit 36 হচ্ছে affidavit of evidence affidavit of PW1 election petitioner himself. ତାର paragraph 11 page 8 and 9 ଯୋଉଥିରେ କି ସେ କହୁଛନ୍ତି ସେମାନେ ଗୋଟେ ଆଇଏ ଦାଖଲ କରିଥିଲେ 15/2022 praying therein to direct election commission of India to produce and proof uploaded data of 2/4/2019 by the RO through its authorized representative in terms of section 65B of the Indian Evidence Act. সেটাকে প্রেস করলেন
paragraph 11 টা মাইন্ড exhibit 36 that IA is still pending এটাକୁ ପ୍ରେସ୍ ବି କଲେ
36 ତ
ଆଜ୍ଞା ଆଜ୍ଞା
35 ଟା କଣ
paragraph 11 page 8 and 9
କଣ ଲେଖା ହେଇଛି ଟିକେ ପଢି ଦିଅ ମୁଁ ଦେଖୁଛି
I have also filed IA 15/2022 praying therein to direct Election Commission of India to produce and prove the uploaded data, that is all the nomination papers along with the affidavits filed by the respondent Muhammad Mokim before the returning officer of 90 Baravati Kotak Assembly constituency and uploaded by the returning officer on 2/4/2019 in the web portal of the Election Commission of India, already preserved by order dated 28/2/2020, passed in IA 24/2020, duly authenticated, certified in terms of section 65B of the Indian Evidence Act through the authorized representative of Election Commission of India. କିନ୍ତୁ ସେ ଆଉ ତାଙ୍କୁ ତଲବ କରିକିରି ସେ ଯୋଉ ପ୍ରମାଣଟା କରେଇବା କଥା ସେଟାକୁ ଆଉ କରେଇଲେନି
Yes.
That's all. So far as 7A and 7B is concerned, my reply is concluded here. ଆଉ କାଲି ପରଦିନ ସେ କେତେ ଗୁଡା ଡିସିସନ ସାଇଟ୍ କରିଛନ୍ତି ଆପଣଙ୍କ ପାଖରେ 15ଟା ଡିସିସନ. I will explain and distinguish those decisions as well as paragraph 7C and 7D.
So, Mr. Mishra, suppose these portions are deleted.
Minor.
Then, let us say the format contains 20 pages.
Minor.
And some of the parts in which it is mentioned that strike out or score out, whichever is not applicable.
Score up?
So, if you totally delete that portion, that was the thing. So, somebody's nomination paper may be 17 pages. Maximum would be 20. But it may reduce in some cases who have totally deleted it. But that in no way affects the rights of the public to know their candidate.
Under 19A.
ମାଇଲର ଜଣେ ଟାଇପ କଲେ ସେ ଟିକେ ବୋଲ୍ଡ ଅକ୍ଷର ବେଶୀ ସ୍ପେସ୍ ଦେଇକରି କଲେ ସ୍ପେସ୍ ଟା ବଢି ବି ଯାଇପାରେ
No, ମାନେ generally ଯଦି ସେଟା ସେଇ ଫର୍ମାଟ ବି ଉଠେଇକିନି ଦିଆଯାଏ ଯୋଉଟା କି available ଅଛି ୱେବସାଇଟ ରେ So let us say, for example, hypothetically that it is 20 pages. But once you take out some of the parts, so obviously it will be reduced. So
But that does not affect the
that-
right to know
हाँ.
by the people under section 19A.
So it does not necessarily mean that you should you may yourself type it out as you pointed out,
Right.
or use your computer also, but all the columns etc which
Relevant.
are the relevant, that should be there.
Minor.
Cannot
All information should be
all information regarding the particular candidate is to be placed.
Those are two characteristics. ଜନତା ଜାଣିବେ, ଭୋଟର ଜାଣିବେ, ତାଙ୍କ ଜାଣିବା ପାଇଁ ଯୋଉ ଗୁଡାକ ଦରକାର ସେଗୁଡା ରହିବା ଦରକାର, ଆଉ ଯୋଉ ଗୁଡାକ ନଟ୍ ରେଲେଭାଣ୍ଟ ଫର ୟୁ ସେଇଟା କାଟିଦେଲେ ବି ଜନତା ପ୍ରିଜୁଡିସ୍ ହଉନା, ଭୋଟର ପ୍ରିଜୁଡିସ୍ ହଉନା।
ଏବଂ ଆଉ ଗୋଟେ କଥା ହଉଛି ଯଦି ବି କିଛି wrong information ଦିଆ ହେଇଥିବ, then the other side will know he at the appropriate time, even if he has not then and there he has not challenged, but his right is preserved.
Even that can be deferred to a stage of election petition decided by your lordship.
Yes.
ସେମିତି ବି ସେ କିଛି ଦେଖେଇଲେନି।
So far as that criminal cases are concerned, mainly they say that no, he has reflected 13 cases, it's all right, but some offenses have been wrongly mentioned.
Court number
description of offense ta ठीक से दिया ही नहीं, court रो ना केते गुड़ाको ये ହେଇଛି, but 13 cases he has given. So and they additionally said that when it requires that you should furnish correct information about the criminal cases also, and you have given wrong information about the offenses, in some cases, and the court name is
name
also,
of the court.
Name of the court. If a candidate wants to go to that concerned court to check out what is the actual allegation against you, he may not get it because it is pending in some other court. In some, so
ଆଜ୍ଞା ମୋର କେସ୍ ନମ୍ବରଟା ମାରିଦେଲେ ସବୁ ଡିଟେଲ ବାହାରିଯିବ। ମୋର କେସ୍ ନମ୍ବରଟା ଯଦି କରେକ୍ଟ ମୁଁ ଦେଇଛି 13ଟା ଯାକ, ସେ କେସ୍ ନମ୍ବରଟା ମାରିଦେଲେ କୋଉ କେସରେ କଣ ଅଭିଯୋଗ ମୋ ବିରୁଦ୍ଧରେ ଅଛି ସେଗୁଡା ସବୁ ବାହାରିଯିବ। So there won't be any difficulty for a voter to know the details. ଆଉ ସେ ବି ଗୋଟିଏ କୌଣସି ଭୋଟରକୁ ଏକ୍ସାମିନ କରିନାହାନ୍ତି କୋର୍ଟରେ ଯେ ଭାଇ ଏଇ କାରଣ ଯୋଗୁ I could not find out. That could have been a case.
That is an hypothetical argument they advanced. That is
ଯୋଉଟା ଦଫା ଭୁଲ ଅଛି ବୋଲି କହୁଛନ୍ତି ସେ ଏଫଆଇଆର ଦେଖେଇକି ପଚାରିଲେ। ଏଫଆଇଆର along with your day to day order sheet ଗୋଟିଏ ଏକ୍ଜିବିଟ୍ ହେଇଛି, କିନ୍ତୁ ଅର୍ଡର ସିଟ୍ ରେ କଂଗ୍ରିଜେନ୍ସ ନିଆଯାଇଛି କମ ଦଫାରେ। ଇଏ ବୁଝିପାରିଲେ ନାହିଁ ଆମର ରେସ୍ପଣ୍ଡେଣ୍ଟ, ସେ ଦଫା ଦେଖିକି କହିଲେ ଏଇଟା ବୋଧେ ଟାଇପୋଗ୍ରାଫିକାଲ ଏରର, will show it tomorrow.
No, one thing is that suppose the FIR is registered in this case, nomination paper is filed in 2019. FIR is registered under 5 offenses. Okay, then charge sheet is filed with lesser number of offenses.
Exactly. Your lordship put that question to them.
Or cognizance has been taken
lesser offenses. So he is not required to mention all those offenses which were there in FIR. He has to mention the offenses under which charge sheet is filed or cognizance taken.
That is the language employed.
That is the language employed by Honorable Appeals Court. Either charge has been framed, that is in the section 33A, and Honorable Appeals Court not only charge has been framed,
cognizance has been taken.
Cases where cognizance has been taken, ତାକୁ must ଦେଖେଇବେ। ତାଙ୍କର ପ୍ଲିଡିଂ ରେ ନାହିଁ କିମ୍ବା ସାକ୍ଷୀରେ ବି ନାହିଁ ଯେ ଏଇ କେସ୍ ରେ charge has been taken or cognizance has been taken. Charge has been framed or cognizance has been taken. ରାଦର ବହୁତ କେସ୍ ରେ ଫାଇନାଲ ରିପୋର୍ଟ ମଧ୍ୟ ଆସିନି, 10 ବର୍ଷ 12 ବର୍ଷର କେସ୍, ଭିଜିଲାନ୍ସ କେସ୍ ସେମିତି ରେଜିଷ୍ଟର୍ଡ ଅଛି।
ସେଇଟା ତ ସେଇ ଷ୍ଟେଜରେ ରହିଛି, ମାନେ FIR ଷ୍ଟେଜରେ ହିଁ ଅଛି, ମାନେ proceed କରୁଛି investigation, but ତାପରେ ଆଉ କିଛି development ହଉନି.
ଆଜ୍ଞା
So the moment charge sheet is filed, one development.
ନାଇଁ
Cognizance taken, another development. Charge framed, another development. So that is how what was there at that particular point of time when the
ସେଇଠି ରହିଯାଏ
nomination paper
stagnant
ସେଇ ଜିନିଷଟା ଇଏ
still
କରିବେ.
respondent ସବୁ show କରିଛି
ହଁ.
ଏତେ ବି ନୁହେଁ।
All right, we'll take up this matter tomorrow.
2 PM ରେ।
Yes, of course. କାଲିକି ଦିଟା ହବ. ଆସନ୍ତୁ କୁହନ୍ତୁ ବାହାର ସବୁ ବସୁଛନ୍ତି. ତମେ ଦେଖେଇଲନି ଡିସପ୍ଲେ ବୋର୍ଡରେ ଦେଖେଇଲନି ହଁ ଷ୍ଟେଟ୍ କାଉନସିଲ କେହି ଆସିନାହାନ୍ତି ଆସନ୍ତୁ ହଁ
Weekly list item number 1.
লিস্টটা পড়ো না yes judgment is one and same okay
But in the meantime, my lord, one of the co-appellant, my lord, is an accused in as accused configured as accused number 3, my lord, Sanatan Das alias Tonna. He has already been admitted to bail by this honorable court on the ground that he was all along on bail and PW7 that only eyewitness has also not implicated that that appellant in the alleged crimes.
no it's all right you hand over this copy of the order to and
Let it admitted first.
whether this petitioner this appellant was facing trial along with those okay all right দেখুন hard admit call for the trial court record
And the LCR is available to that case.
the learned counsel for the appellant submitted the trial court record is available in CRLA number 1144 of 2023 filed by who accused Sanatan Das challenging the impugned judgment and order of conviction. Let the registry tag this case with CRLA number 1144 of 2023 and CRLA number 1155 of 2023. 1155 टा तो next item ता ता धीरे से दीटा नंबर दे देवे 1144 तो रहिबो ता सहित एक नंबर आइटम टा भी रहिबो हला the learned counsel for the petitioner IN number so on so this is an application for bail learned counsel for the petitioner has filed the bail order copy of who accused Sanatan Das alias Tonna passed in CRLA number so and so 1144 of 2023 order dated hochi 22/1/2024 and handed over a copy of the same to the
Yes.
to the Law and Council for the state in court today. So you require the evidence copy or that would be
Yes.
available in that case?
Whether available, I don't know. Let us know.
Law and Council for the petitioner handed over the copies of deposition of all the witnesses examined in the trial court, Law and Trial Court to the Law and Council for the state in court. Put up this matter next week for consideration of the bail application. ଦେଇଦଉନାହାନ୍ତି ନମ୍ବର ଏକାଥରେ ବେଶୀ ଆଉ କଣ ଦିଟା ନମ୍ବର ଦେଇଦେବୁ ସେଗୁଡାରେ କଣ ହେଇଛି ପୋଜିସନ ନାଇଁ ବେଲ ହେଇଛି କି ତା ଦେହରେ ହଉ ଠିକ ଅଛି ଓକେ ଏଇ ଗୋଟେ କେରେ ତାହେଲେ ବେଲ ହେଇଛି ବେଲ ଅର୍ଡରଟା ଦଉଛନ୍ତି
Item 3.
Item 3, I may be permitted, my lords.
Yes, Mr. Rao.
Criminal appeal against judgment of conviction and the sentence part is at page 30.
Item 5.
Hi, Mr.
Appearing to the petitioner, my lord.
Yes, what is this, Mr. Das?
Lord, here the appellant is the complainant, and the challenge is to the judgment of acquittal and the order of sentence, my lord.
What offense the accused persons were facing prior?
Lordship. My lord, if sees page 29. My lord, opposite party number 5 to 9, who are accused number 3 to 8, have been acquitted, while the court below has convicted OP number 2, 3, and 4 only under section 323 and 324.
So the main offense was 307.
307, your lordships.
Who is the injured? Who are the injured?
Lord, injured are PW 4 and 5. The victims.
Where in the trial court has discussed about the medical report of those two witnesses, 4 and 5?
Yes.
5 and 6.
Injured.
ନାଇଁ 4 ହଉଛି ଆଇ ୱିଟନେସ୍
ନାଇଁ ମୁଁ injured କଥା କହୁଛି
injured ହଉଛି 5 and 6.
Okay, not 4.
No.
So Mr. Das, where the medical evidence is discussed, in which paragraph? And what are the injuries sustained by the?
Yes.
Mr. Tripathi?
Yes, ma'am.
वो discussion है जी?
Para 6.
Para 6. Para 6. Page 21.
6 रे okay 4 and 5 are the victims 4 and 5 କହୁଛନ୍ତି victim ବୋଲି
4 and 5 victim ଆଜ୍ଞା but ଏକା ସାଙ୍ଗରେ ଥିଲେ so 4 is also an eye witness corroborating 5's version.
ହଁ କଣ ହେଲା injury କାଇଁ
Lathi blow then
deal the cricket stick blow on the head for such as they have sustained so and so. This is the evidence discussed. I am asking about you the medical exemption report. Okay, page 23 ରେ ଅଛି
23 ରେ second
23 ର sub paragraph ରେ ଦେଖନ୍ତୁ 9 and 12 are the doctors
Yes.
associated with in providing treatment and furnishing so and so. So on so and so he examined Ashok Kumar Sia. Ashok Kumar Sia is PW?
4 minutes.
4.
4 PW4.
4 Ashok Kumar Sia. Okay. And found one head injury on the occipital region. Trauma on the right leg, multiple abrasions and bruises throughout the body, and proof so and so. Okay. Further, the emergency so and so crime dog. Okay. Not only that, but also the prosecution has ruled Dr. so and so as PW strength that he examined so and so Tata Hospital found Ashok sustained fracture injury in the left hand and the same to be grievous in nature. He proved the medical prescription of the victims. Basing on so and so submitted a report, the medical reports on
and nothing has been brought to the contrary to dislodge your lordships.
Next. So the person of the victim is well corroborated. Okay. That they say that X-ray
Plate was not produced, your lordships.
The plate was not produced.
Yes. That is the sole ground. And further convicting my lord accused number 1 and 2, the benefit of PO Act has been rendered. And thereby releasing those 2 accused, only 2 accused out of the 9 convicted. They are also being released under PO Act.
Abhishek Das, line counsel for the appellant. This criminal appeal has been filed under section 372 of the CRPC by the appellant Damayanti Sia. Was the informant in Jakopura PS case number. He's the informant, na?
Yes, he's the informant.
In Jakopura PS case number 111 dated 14/12/2020. Challenging the impugned judgment and order dated 8/12/2023. But one thing, Mr. Das,
Lordship.
what 372 says,
Yes.
come to 372.
Lordship. That proviso, if your Lordship.
That such appeals shall lie to the court to which appeal ordinarily lies against the order of conviction of such
Lordship.
court. So that means, suppose now the assistant session judge has found of the appellants guilty under 323 and he has let out on PO Act.
PO Act.
So if they prefer the conviction, the appeal, they will prefer before the session judge, not to the High Court, because the against the order of conviction, once it that sentence crosses that 7 years limit, then they will have to approach this court. Otherwise, ordinarily the appeal lies to the session judge against the order of assistant session judge. So, so the acquittal order or inadequacy of sentence, whatever it may be, that will be challenged before the learned session judge, not before this court. So how your appeal is maintainable here, this 372 appeal? Just go through it, the provision, and we'll take up this matter some other day.
Lordship.
Okay. Heard Mr. Abhishek Das, Learned Counsel, appearing for the State of Rohila. I challenge to want so. It the proviso to section 372 reads as follows. Quote kar debe, provided that so and so. Since in a case of this nature, the appeal ordinarily lies against the order of conviction passed by the learned assistant session judge to the session judge Jajpur. And the learned counsel for the appellant shall satisfy this court as to how this appeal is maintainable before this court. Put up this matter. When we will take up this matter?
Lordship, next week, Lord.
Okay. Next week you want it to be on 5th of February?
5th, Lord.
Okay, there is no problem on that day?
No problem.
Okay. On 5th of February 2020. Yeah.
Grateful.
Item 6.
The petitioner, the appellant has preferred this appeal against the order of conviction passed by the Honorable Special Judge Vigilance in Sundargarh PS case number 35 of 2009, wherein the London has convicted the appellant to undergo for 4 years fine.
What is the operative part of the order?
Page 69.
Running page or internal?
Running page 69 and page 59 of the judgment.
Just a minute. Convict to 4 years each and pay fine of rupees 1 lakh so and so under 409. Then 1 year 50,000 and in default so and so 13(2)(13)(1)(c) of this one so. So now because of this sentence you must be in judicial custody, right? You are on bail during trial.
Yes, Lordship.
Okay.
We were in custody for 1 month. Subsequently, after the judgment, we are in custody. For the past 2 months, we are in custody.
Yes, Mr. Das.
Yes, my lord, I have received the copy. 2 bail applications, 2 stay realization fine amount petitions have been filed. Another interim bail petition has been filed as per the cause list.
Interim application has been filed as because the petition appellant's son marriage has been fixed on 31st January.
Oh, good not fresh from this bail.
IA number 98/24 at lage.
To not fresh tell me that.
Lordship, IA number 98 of 2024. Lordship.
Okay, IA number. Acha, it a hard admit code. Call for the trial court record. IN number 98 of 2024. Mr. Mahanti doesn't want to praise this application, so it is not praised. Then IN number 166 of 2024, application for bail. He was on bail, and after conviction, he has been taken into custody, so bail allowed. Then one of them, then again stay or be the application for
Lordship, 99 maybe not.
99 of 2024. এটা হচ্ছে the other one is allowed. Stay relation. Extra money যদি নেইতে ফিরিয়ে দেবে client. Yes, next.
Interim bail application is there.
No, interim bail upon bail.
169 2000.
Interim bail. এটা not face করবেন. Yes, এটা not face.
I will file my appearance by the end of April, my lord, and free copy of the
free copy of the order. Yes. Name of Mr. Das be reflected in the call. Yes.
Item 7.
Your Lordship, page number 73.
73.
Yes, my lord.
Okay. 73 version. All right. RI for 4 years and fine 1,50,000 in default to undergo so and so 409. Then so and so in default to undergo so and so. Okay, 13
Missing in custody 6-8 January, my lord.
You were on bail during trial.
Yes, my lord.
I think this is connected to the other
Connected
item.
matter item 6.
Right.
Yes, my lord. Co-accused of item number 6.
So
He is Sarpanch and that appellant was Panchayat extension
same
of
order कर देवे ये जो bail granted admit करी bail grant कर देवे और stay relation of fine दे देवे and it is to be tagged with that CRL number 35 of 2022 है ना, free copy of the order, name of Mr. Das to be reflected, all these things to be written. Yes.
Mobilized, my lord.
And we'll take down that hard Mr. Umas Shankar Patel from the virtual High Court Sundargarh on it. Yes.
the copy should be handed over to us, my lord. It was handed over. I received it in court today from the learned counsel. So they are not serving.
Which one?
This petition copy was not served on us.
Oh, why are you not serving it in on advance, Mr. Patel?
To vigilance.
To the vigilance council
Copy has been served on the email ID of
He said that
Advocate
now
General.
yes,
it should be served in advance on
yes,
it.
my lord. Yes, my lord.
My lord, may I pray item number 6 may be reflected vigilance in the cause title.
All right. Item number 6 रे लिख दियो तो after state of Odisha, vigilance be reflected in the cause list and spoke.
Obliged.
All right. Yes.
Item 9.
'23 to 12, 2013, 23 my lord.
Conviction matter.
Milord.
My lord, OPDI my lord.
Case page number
73 Milord on
73. RI for 5 years, 50,000. Okay, 6 OPIDR. Then his name is Prince Kumar. Okay.
My lord.
Then 420 also 5 years. Then 7 years, 467. 3 years, 468. 2 years, 406. 2 years also. 5 years also. Oh. So the highest punishment is 7 years, right?
My lord.
All right. You supply the deposition copies to the state council. Admit call for the trial court record. Deposition copies to be supplied to the land and council, special counsel for the state of Odisha. Mr. Names of Mr. Vivekanand Bhuya and Mr. J.P. Patra to be reflected in the cause list henceforth. Interim application for bail and stay relation of fine to be considered after receipt of the trial court record. Yes, next.
Item 11.
Date my lord.
Yes.
May I please, Lordship? My lord, the appellant has been convicted under section 376A(b) of IPC read with section 6 of
Sentence.
Item 12.
Yes.
My lord, conviction matter, my Lawrence.
Item 12 has been reflected as vigilance. Neither
No.
copy has been served on us.
Vigilance matter, my lord.
हमको दिया है नहीं कि तुमको दिया है नहीं खुद से ले
I will supply an.
It's a vigilance matter.
My lord, vigilance.
So
let it come up next Monday, my lord.
The Land and Council, Mr. Sanjay Kumar Das, Land and Standing Counsel for the Vigilance Department, submits that he has not received the copy of the appeal memo along with the impugned judgment and interim applications. Mr. Savai Kumar Das, Land Council, appearing for the appellant, submit that he will supply the same during course of this week कर दो जी.
In course of the day, my lord, I have just.
आज ही दे देवे.
अच्छा,
by tomorrow कर दें. By tomorrow.
my
Put up this matter and we commencing from 5th February 2020. The name of Mr. Sanjay Kumar Das be reflected in the cause list. Yes.
Item 13.
Please. My lord, item 13, 14, 15. Notice today they are going to serve the notice.
Notice has already been served.
ଆପଣ ଆଜି ସର୍ଭ କରିବେ ବୋଲି ଅଛି
ମତେ କହିଲା
କେବେ ସର୍ଭ ହେଲା?
3 तारीख
ହଁ
3-1
କାହାକୁ ଏଇଟା
3-1 ରେ
3-1 they have sent letter to the advocate general officer
ନାଇଁ ମୋ ପାଖରେ
ये approve दिया
ବୁଝିଦିଅନ୍ତୁ କାଲି ନେଇଯିବା ନହେଲେ
ହଁ।
ହଁ ଏଇଟା କାଲିକି ନେଇ ଆସୁଛି ଆମର ଲିଷ୍ଟରେ ତ ଏ ତିନିଟା ଯାକ ମ୍ୟାଟର ସେଇ ଗୋଟେ ଇଏରେ କୋ ଆକ୍ୟୁଜ ମାନେ ଗୋଟେ କେସ୍
co-accused other co-accused ଯଦି reason ପାଇଁ
alright ଖାଲି ଲେଖିଦେବେ learned counsel for the state seeks some time to obtain instruction when the notice on the informant has been served. Put up this matter tomorrow. Yes, इतना टी आगे कर दो है ना?
Item 16.
13, 14, 15.
13, 14, 15 तीनटा
Item 17.
17 SC ST notice to go.
fresh matter.
Yes,
Well,
Same order.
I have already solved extra copy.
हाँ extra copy sort କରିଛନ୍ତି ବୋଲି court ରେ ଲେଖିବେ.
Oblige.
Item 18.
this is also SC ST पहिला
Fresh matter.
yes ma'am
Notice जाइनी. All right. Extra copy to be served. CDCA confirmation letter.
Item 19.
Letter received so and so regarding extension. Extension allow कर देवे जैसे मागिशन का communicate the order. Yes.
Item 20.
Item 20 may I please lordship. There is a delay lordship.
कौन है what is the CRL for?
The CRL for vehicle of release. Release
Release
of vehicle.
155 days.
155 days lordship.
इसलिए condone कर दूँगी note instruction है देखो IA number so and so there is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 155 days in preferring this CRLA. Land Council for the state has no serious objection for condoning the delay. After going through the averments taken in the IA and hearing the Land and Council for this so and so, and since it's a criminal appeal, which in which prayer has been made for release of the vehicle in favor of the petitioner. I am inclined to condone the delay. Accordingly, delay is condoned.
Only thing, my lord, sorry, it should be filed under section 452, not under.
ନାଇଁ ସେ ତାଙ୍କର ଲେଖିଛନ୍ତି ଏଠି କାଟି ଦେଇଛନ୍ତି ସେ 454 ସେଟା ଲେଖା ହେଇଛି ସେଟା ସେ ଆପଣଙ୍କ କପିଟାରେ କରେକ୍ସନ କଲେ ତାଙ୍କ କପିଟା କରେକ୍ସନ କଲେନି
ठीक है
ତ the Land and Council for the state seeks some time to obtain instruction in the matter. Put up this matter. This सप्ताह पर पकेगी. Yes.
Obliged.
free copy.
हाँ free copy of the order.
Obliged.
Item 21.
What is this matter, Mr.?
May I please your lordship?
Sir.
My lord.
What is this matter CRLA for?
My lord, matter is rigorous imprisonment for 5 years and pay fine of rupees 50,000.
What is the operative part of the judgment?
Lordship, page number 32, lordship.
You have not served a
If
copy.
you
Mr. Counsel, you have not served a copy of the your appeal memo on the State Council.
Lordship, let take him next week. Lordship, in the meantime,
And counsel
supply the copy.
State submits that he has not received the copy of the appeal memo along with the interim applications. Let the copy of the interim appeal memo along with the impugned judgment and copies of the interim applications be served on the Land Council for the state during course of this week. Put up this matter next week. Yes.
Okay.
Item 22.
Delay is there in preparing the appeal.
What is this?
Item 20.
Deputation copy to be supplied to the Land Council for you. Yes, next.
Madam, please, Lordship, madam. There is delay for 20 days, my lord.
What is the CRLA for?
My appellant was convicted under section 304 of IPC and sentenced to undergo 10 years, my lord. Upper page 39, my lord. Running page 39.
39 RI for 10 years. One. Okay. So, what is the delay? Delay is 13 days. All right. So delay condone. Hello. Admit. Call for the trial court report. Interim applications for bail and stay relation of fine to be considered after receipt of the trial court report. Deposition copies to be supplied to the Land Council for the state. Yes. Next.
Item 24.
डिले कानून कर देगा है ना एडमिट कर दियो तो and interim applications for bail and stay relation of fine to be considered after receipt of the trial court report. Deposition copy to be supplied है ना